welcome back. We thank you for joining us for this KVUE News Plus special coverage of the impeachment trial of suspended Texas Attorney General Ken Paxton. I'm Ashley Goudeau.
And I'm Tony Plohetski. Thank you for joining us on what is our 8th day of testimony in this historic impeachment trial of Ken Paxton. We've been hearing from the very first defense witness this morning, who spent the most of the morning on the stand doing both direct and cross-examination before he was dismissed and allowed to leave just before the lunchtime hour.
Let's talk a little bit about who the first witness that we heard from this morning was. It was Justin Gordon. He is the chief of the Open Records Division for the Texas Attorney General's office. And so there are two articles really related to the open records process and what the House managers say was violation of that process and violation of that law by Ken Paxton in order to, in one of the articles, they allege that he instructed his office not to issue an opinion when they wanted to issue an opinion, as we heard from some of the top aides that testified for the prosecution. And then another article related to that open records process is that they said, Paxton, you misused that law, violated that law, and turned over some sealed documents to Nate Paul. And what we heard from Justin Gordon was that in all actuality, DPS missed a key deadline, that they had to file a response, that they did not file a response, and that sort of led to that no opinion. That
there's a presumption that the documents have to be released at that point.
Mm-hmm. And that was one of the reasons why, according to Gordon, certainly, after lunch.
It's been a long 8 days, actually.
Yes, according to Gordon, that Ken Paxton said not to issue an opinion one way or the other because DPS didn't respond to that, what they had 15 days to respond to and to say why that information should not be released. And then, of course, we have the redacted information that was given about the warrant served on Nate Paul's properties to Nate Paul, and learning today that the FBI is actually who also gave Nate Paul a copy of that document.
Via his lawyer, a redacted document. And then the second witness for today, it was Austin Kinghorn, the Texas Attorney General's Associate Deputy for General Counsel. He took the stand.
I want to say a title he got after the whistleblowers had either been fired or quit.
That's right. He's, according to his LinkedIn, and they didn't exactly go through all of this, but he was hired, then promoted, as Ashley noted, into a position that was vacated by one of the whistleblowers. But he was questioned by Chris Hilton, who I pointed out earlier. Chris Hilton worked in the Attorney General's office as part of Ken Paxton's staff, but is among about a handful of employees in the state agency who took a leave of absence from his job as a state employee to assist in Ken Paxton's defense. But Kinghorn spent considerable time on the stand essentially defending his boss, saying that he is not familiar with him ever doing anything illegal. We saw Chris Hilton walk through multiple impeachment articles, really seizing on a couple of things, including an internal investigation conducted by the AG's office that basically said Ken Paxton did nothing wrong. But one of the impeachment articles that they spent some time talking about, I believe it's Article 8, and that is the assertion that that Ken Paxton ordered a sham investigation of his agency to clear him of any wrongdoing.
And if we take a live look at the Senate floor now, I wanted to point out to the gentleman to the left of your screen in the blue suit is Chris Hilton, who Tony was talking about and talking to you about earlier in regards to the defense team, and who is a member of Paxton's staff who took sort of a break from the defense team to represent Paxton today. And what we really heard when Kinghorn was on the stand was some pushback from Aaron Epley, who was doing the cross-examination for the prosecution, about his allegiance, about Kinghorn's allegiance to Ken Paxton and certainly to proving up his case. She noted, at one point, and I think it raised some eyebrows, when he referred to the Attorney General's office as Ken Paxton's law firm.
As Ken, yes.
And referring to Ken Paxton as the client, and Aaron, Epley pushing back, saying the state of Texas, is the client.
And it went as far as to say, well, his name is essentially insinuating that Ken Paxton had a lot of latitude because his name is on the wall.
Right, and so that he could have access to any documents, and he could sign whatever contracts or papers that he wanted to sign because it's his office. And so that was certainly interesting to hear some of that pushback. But then she also raised this point that every time she talked to Kinghorn during the discovery process, which both sides agreed that they would both be allowed to talk to witnesses and potential witnesses as they saw fit, that whenever she would request documents of him, because he is who she would have to request documents from to submit into evidence, that those documents would then, the next day end up in the findings, or the motions from the defense team. And so almost her insinuating or stopping just short of saying...
She barely stopped short of accusing him of kind of some shady conduct.
And questioned whether he was being pressured to do that, or, certainly if he was doing it at his own free will of sort of giving the defense whatever and tipping the House's hand.
I thought it was interesting, too, that she began her cross-examination by going right there. And we saw Chris Hilton strenuously objecting to that, but clearly that was an effort on her part to try to impeach that witness, to undermine his credibility, to the jury, to the senators.
And I think also when you think about the time factor that weighs heavily into this, the prosecution only had, when we started the day, the prosecution only had 2.5 hours left to present its case and obviously not to present its case because they rested yesterday, but 2.5 hours left for cross-examination compared to the House, which had the defense, which had 8.5 hours. And so the House really has no time for pleasantries anymore.
They have no time for pleasantries, and actually, as we pointed out earlier, we could very easily get to a situation here, in fact we may, where the defense is still putting witnesses on the stand, but that the prosecution is out of time. They no longer have time to cross-examine the defense witnesses. Actually, another thing, we were talking about this before lunch, and that is at some point we can expect today the senators will take up a motion that was filed by the House impeachment managers that would essentially combine, there are two prongs to a vote that the senators will take at the conclusion of this trial. And the first prong is whether or not to convict Ken Paxton, which would trigger his removal from office. But then the second prong is a measure that would that would ban him from serving in an elected position in Texas. But there is a proposal that would essentially wrap those two things together.
Yeah, the House, and it certainly is an interesting proposal that they want to have, tie that into. So if he is convicted, he will be convicted, removed from office, and banned from running for office in the state of Texas again. And certainly not sure on the strategy as to why they would want to do that, but they presented that motion yesterday. It has to be laid out before the senators for 24 hours and pursuant to the rules, which we want to know. The senators wrote the rule as two separate rules. They wrote this to happen as two separate votes. And frankly, I don't know how they are going to take to the prosecution and House managers wanting to change the rules that they spent 2 days deliberating after a committee spent time
drafting them.
The initial draft of the rules. But we'll see that had to be laid out before them, and any changes to the rules have to be voted on by the actual House.
And as we pointed out, and as we clearly saw yesterday, it is no surprise at this point to see motions get filed in this case and then pulled back. We have seen that. We certainly saw that yesterday with the effort by the defense to file a motion for a directed verdict, which would have essentially ended the trial, and then the House filing a response to that. Clearly, they had one in their back pocket, ready to pull out in anticipation, and then within an hour or so, maybe give or take a little bit of time, we saw both of them rescinding those motions.
So just to check at the time now, it's about 1:50, and the House was set to come back at 1:30. And you can see a few senators milling about on the floor there, which before they, come back, they have to enter into the room all together, which, make of it what you will, that they're still, going about the floor. We're seeing Angela Paxton there greeting Lois Colcourse and heading to the back after taking a quick look at the gallery to see who's there. She's been, we have seen her quite jovial.
She has not cowered one bit as testimony undoubtedly became uncomfortable for her, specifically yesterday with the testimony of Drew Wicker, who was one of Ken Paxton's aides. Clearly, I think in terms of deeply personal testimony, the worst is probably behind Angela Paxton at this point, given that the state has rested and witnesses to be called from this day forward will be defense witnesses.
Well, it's certainly interesting to see her, her actions, and as we observe her, yesterday, which we anticipated because the potential of having Ken Paxton's mistress on the stand and her coming out in the afternoon and blowing kisses to people in the gallery and waving, seemingly unbothered by it all and by what is happening.
Seemingly, I mean, certainly we can't know what's in her mind and in her heart, but to Ashley's point,
actions.
Absolutely. I mean, she clearly is waving and throwing kisses to people in the gallery, spectators in the gallery. But again, just to underscore, she's been there and her husband has not. We are now on the 8th day of this trial, and Ken Paxton showed up on day 1 as part of the plea to plead not guilty, which, by the way, he did not even speak himself, but did so through his attorneys. And then he split. He hasn't been seen since.
The rules, which we like to point out, the rules were, written and approved and voted on by the Senate, and they did not require him, the rules do not require him to be present. They required him to physically be present in the chamber when it was time to enter a plea, but that was it. And so he left that afternoon.
And in terms of where he's been or what he's been doing, we know one thing he hasn't been doing. He was suspended in May, immediately after the House approved the impeachment articles. At that point, constitutionally, he was suspended from office. So he is not running the day-to-day operation, of course, of the Attorney General's office.
But certainly has been doing some campaigning off of this very event, sending out, his campaign, sending out countless emails to supporters to say that he will, asking for those campaign donations. And, there is a gag order in place, but certainly using language to say that this is the establishment and rhinos who are trying to get him out, and they're trying to get him out of office. And so please help us. And then,
I was going to say, booking a very important,
That's where I was going. And so while he hasn't been, while he's been doing this campaigning, he also shared on Twitter yesterday that he's going to Maine next week for a sit-down interview with Tucker Carlson to talk about, quote, the last 2 weeks in Texas politics. It should be interesting, ! End quote.
Exactly. And just with regard, a couple of things about that. Ken Paxton, by the way, just to note, has declined repeatedly and does decline repeatedly to talk to Texas-based news outlets despite multiple requests. So we will have to hear what he tells Tucker Carlson. And then in addition to that, we have seen some political momentum heating up as well, with both Donald Trump and Donald Trump Jr. tweeting support for Ken Paxton and sharing on social media support for Ken Paxton within the past 24 hours or so.
Yeah. So, and them calling for this to end, saying that, again, sort of that language of, we've heard a lot of strong language about what is felt of this trial from conservatives. So you can see the remainder of the senators starting to walk out of the back room now and have a seat at their desks, where we will resume
hearing who the next witness is.
And hopefully, I'm hoping selfishly we get a time check before we hear who the next witness is, because that's one of the things I'm certainly interested to see. Is just
the clock is literally running out.
Yeah, how much time they have left. Dan Patrick said earlier this week that he anticipated both sides would be out of time by today.
Exactly.
So it will be, and once that happens, they'll each get an hour to present rebuttal evidence, and then they'll have an hour for closing statements before it goes to the jury.
Yes, Your Honor. Amy Hilton for the Attorney General.
Would you call your first witness?
Yes, Your Honor. The Attorney General calls Henry De La Garza.
Will the bailiff bring in Henry De La Garza? Amy, there's some documents still up here if you want to get those removed.
Henry De La Garza is an assistant attorney general, obviously an employee of Ken Paxton's staff, a longtime employee, according to online information. He joined the agency in 1995, so clearly a veteran of the agency for decades now.
You can see him entering onto the Senate floor and making his way up. That's Austin Osborne directing him. He's a sergeant of arms for the Senate, but serving as bailiff during this trial.
Need to swear you in. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon the hearing of the Senate of Texas of the impeachment charges against Warren Kenneth Paxton Jr. shall be the whole truth. Shall be the truth, the whole truth, and nothing but the truth, so help me God. Please be seated and speak closely to the microphone. Hold on, I understand we have a new court reporter I need to swear in also. Where is our new court reporter? You raise your right hand, step to the side. Hi. I do solemnly swear or affirm that I will correctly transcribe and report all the proceedings of the trial of Warren Kenneth Paxton Jr. on the impeachment, so help me God. Welcome. Give her a moment, and then when you see she's ready, proceed.
Good afternoon, Mr. De La Garza. Could you please introduce yourself to the jury?
Sorry about that. Yes. My name is Henry De La Garza.
And I'd like to just have you take a minute and a half or so and give us a little of your background, where you're employed, and what you do there.
I work at the Office of the Attorney General, an agency of the state of Texas, and I am the HR director, the chief employment counsel, and the ethics advisor.
And how long have you held the position as HR director?
Of HR director, interim director, November 2nd of 2020, and then became permanent HR director December 1st of 2020.
How long have you worked for the Office of Attorney General?
I started in 1995 as an Assistant Attorney General 1 and worked my way up.
And what division did you start in? Have you always been in Human Resources?
No, I started in Habeas Corpus Division and then went to Transportation Division and then Human Resources.
How many attorneys general have you worked for at the agency?
Well, let's see. It would have been Dan Morales and then John Cornyn, now Senator Cornyn, Greg Abbott, now Governor Greg Abbott, and then Ken Paxton, and then also the Provisional AG John Scott and Provisional AG Angela Colmenero.
How many years have you been working in human resources?
I started in May of 2008.
You've testified that you've been at the agency for a couple of decades. How would you describe your experience working at the Office of Attorney General?
The agency is an outstanding state agency. It's a great place to work. This is as a lawyer, it's an ideal place to practice law, whether you do civil, criminal, trial, appellate, transactional, plaintiff, defense, whatever. We have it, and as an agency, we're number one in child support enforcement. This is an agency of lawyers, of child support officers, peace officers, and a lot of hardworking employees.
And as the HR director, how many employees at the Office of Attorney General are you responsible for, enforcing agency policy and procedure?
Well, the approximately 4,000 employees that we have throughout the state of Texas. And we also handle human resources work for the State Office of Risk Management, SORM.
And just generally, what are your responsibilities as both the ethics advisor, the HR director, and the chief employment counsel?
Well, it's quite a bit. As HR director, I oversee the HR operations for our state agency, 4,000 employees throughout the state of Texas. I lead a team of 22 talented and dedicated employees. We handle all sorts of HR functions, from hiring, posting, classifications, onboarding, benefits, leave, training, development. We have a wonderful wellness program, and we also have a robust law clerk program. And as Chief Employment Counsel, I, along with the other attorney in the division, excellent Deputy Chief, we provide legal guidance to the managers and supervisors of the agency, and we, make sure, EEO compliance, the rare EEOC charge of discrimination, and workers' compensation, and unemployment benefits. And then as ethics advisor, I provide guidance to approximately 700 lawyers of our agency, mostly on the Texas disciplinary rules of professional conduct, other ethical issues, and then I oversee the agency's fraud, waste, and abuse prevention program. I think I have it all.
I started as a law clerk at the office, and so I certainly appreciate everything that you do for the office. Outside of working in HR, do you have any other experience with employment law?
Yes, before starting in HR, I worked in the transportation division where I managed the employment law matters for TxDOT, another outstanding state agency, and handled the trials, appeals, hearings for state and federal law, for all different types of employment laws. Title VII, Chapter 21 of the Labor Code, FMLA, FLSA, ADA, First Amendment retaliation, whistleblower retaliation, USERO retaliation, workers' comp retaliation, all that.
And so you mentioned the Whistleblower Act. Have you ever taken a Whistleblower Act case to trial?
I actually have.
Okay. And does the Whistleblower Act, does that have certain requirements in order to state a claim?
It does.
And does it also provide specific remedies?
It does.
Is one of those remedies removal from office?
It is not.
And who is a proper defendant under the Texas Whistleblower Act?
The government entity.
Is an elected official a proper defendant under the Texas Whistleblower Act?
No.
Where are Whistleblower Act claims usually adjudicated?
It's a state law claim, so it would be in state district court.
Are you aware of a Whistleblower Act claim ever being litigated outside of the state district court?
Not under the Texas Whistleblower Act.
Are you aware, Mr. De La Garza, that in 2020, a group of high-level staffers made reports to law enforcement about the Attorney General?
I am.
And are you aware that some of those staffers subsequently filed a Texas Whistleblower Act lawsuit against the Office of Attorney General?
I am.
And to your knowledge, is that case still pending?
Yes, in Travis County.
You mentioned that you've worked under a number of attorneys general, and so I just want to ask you a few brief questions about how the agency works. How do most employees of the Office of Attorney General obtain their positions?
Most employees, I mean, we're talking about, just about everyone, would apply through a competitive posting, and then the hiring manager would select the best qualified candidate.
And how did the former staffers who made those complaints to law enforcement, how did they obtain their positions?
They were appointed by Attorney General Ken Paxton.
And so, and to be clear, I think you said there are about 4,000 OAG employees?
Yes, about 4,000.
And about how many are appointed?
We're talking about half of 1%, maybe 0.2% or 0.02%.
Is it your understanding, Mr. De La Garza, that the Attorney General has authority to appoint certain high-level policymakers?
Yes.
And what is that understanding based on?
Well, it's a well-established concept and tradition in the United States of political patronage. This has been affirmed in Supreme Court law, U.S. Supreme Court law, federal law, state law, that elected officials, whether you are the governor or the attorney general or the elected sheriff of a county, that you have the right to hand select people who are going to help you reach the goals and the vision that you've presented to the electorate and who voted you in.
And for those appointed officials at the Office of Attorney General, are those appointed officials still required to comply with agency policies, just like every other OAG employee?
Yes.
At this time, Your Honor, I'm going to move to admit Attorney General Exhibit 431. Counsel and I discussed this during the break, and I understand that there is no objection.
No objection.
Admit AG 431 into evidence.
Mr. Arroyo, could you please pull up AG 431? And could you turn to the second page, please, Mr. Arroyo? Mr. De La Garza, is Exhibit 431, do you recognize this as a copy of OAG policies and procedures?
On the screen, there's nothing on the screen.
Oh.
Hold on one moment. We'll stop the clock for a moment. Pardon?
We've been listening to testimony from Henry De La Garza. He is the Director of Human Resources for the Office of the Attorney General. And right now he's talking about what we allude or where we're going is about the firing of the whistleblowers. Now, what they are paused on right now is they want to look at some of the policies, the documents from the Office of the Attorney General. That is what they are called up and kind of what they are pausing right now on is for those documents to be raised if they are going to be admitted, and then getting them on the screen certainly for him to watch. And so one of the, or rather two of the articles of impeachment are related directly to what happened with the whistleblowers. So article number 6 is disregard of official duty. It alleges that Attorney General Ken Paxton violated his duties by terminating employees in violation of the Texas Whistleblower Act, that he fired 4 of those whistleblowers without good cause or due process, and engaged in a campaign to, spread bad information and sort of ruin their personal reputations. And that's Article 6. Article 7 alleges that a misapplication of public resources, that Ken Paxton misused the public resources entrusted in him and directed his employees to conduct a, quote, sham investigation into the whistleblower complaints, and also that they published that report with false or misleading statements that were made in Paxton's defense. And so what Henry De La Garza is obviously going to be talking about here is what the policy is, and that's what they're waiting on to be able to pull up, is the actual policy from the Attorney General's office. Tony, we noted this before. Several members, high-ranking members of Paxton's office, took a leave of office in order to help with his defense, and we're hearing from another one of them today. Exactly, and they are, in fact, questioning, one of the attorneys questioning Mr. De La Garza right now. Amy Hilton is, in fact, one of those employees who did take a leave of absence from the Attorney General's office to defend their boss. They believe in him so strongly that they stepped away from their day job to assist in his defense. And she noted, in talking with De La Garza, she certainly noted that she worked there and appreciated his work for the office. They're restarting now, so let's listen back in.
And you recognize that as a copy of the Attorney General Office of Attorney General Policies and Procedures?
Manual, yes.
And what is your role, if any, with respect to drafting and creating policies for the office?
Well, since May 2008, I've been pretty active in making sure that our policies are up to date, revising policies with new laws. For example, I know that we've got the new Crown Act and military performance and paid parental leave, things like that. So we make sure that we're always keeping up, and we make changes to the manual.
Do these policies provide that Office of the Attorney General employees are at-will employees?
Yes.
And can you just briefly explain what that means?
Well, the state of Texas is an at-will state since, I think, 1877 or something like that. And it just means that in Texas, you don't have a property right in their job. You can be fired for any reason. A little more? This? Oh. Oh, perfect. Thank you.
Mr. De La Garza, are members of the executive administration at-will employees?
Yes.
Does OAG have an unacceptable conduct policy?
Yes.
Mr. Arroyo, could you please flip to page 43 of Exhibit 431. At the bottom, the Bates stamp should end in 535. Mr. De La Garza, is this the unacceptable conduct policy we were just talking about?
Yes.
And Mr. Arroyo, if you could just flip to the next page, please. And about halfway down on those bullet points, Mr. De La Garza, one of the things that's listed as unacceptable conduct is use of an insubordinate or unprofessional tone towards management. Do you see that?
Yes.
Is that a policy that you wrote?
Yes.
And when did you write that policy?
Based on the date that I saw, it looked like it was in 2013.
And can you explain for the jury why you included that policy in the office's Policies and Procedures handbook?
It just seems typical that most manuals for employers would include something about, conduct and what's appropriate and what's not.
What are the potential consequences for failing to comply with agency policies?
Well, it depends. We look at every situation individually. It could be corrective action, such as a counseling session, a reprimand, but if it's, depending on the situation, it could be disciplinary action, including involuntary separation.
As the Chief Employment Counsel, the Ethics Advisor, the Director of Human Resources, do you provide advice to executive management on matters on employment issues?
I do.
And do you provide advice related to the application of the policies that are contained in AG Exhibit 431?
I do.
I'd like to switch gears a little bit here, Mr. De La Garza, and talk about the ex-staffers, the former staffers that left the Office of Attorney General in 2020. Who was Jeff Mateer?
Jeff Mateer was the first Assistant Attorney General.
And how did his employment at the OAG conclude?
Jeff Mateer resigned on October 2nd, 2020.
And who succeeded him as first assistant?
Because Jeff Mateer resigned and Attorney General Ken Paxton had, a right to then select someone, and under the Texas Government Code, every state agency needs to have an executive head, and at the Attorney General's office, that executive head is the first assistant, and so they pretty much manage the division day to day, and so Attorney General Paxton appointed Brent Webster, and then he began that same Monday, I believe, October 5th, 2020.
At the time that Mr. Mateer resigned, were the other former staffers still employed at Office of Attorney General?
Yes.
And so at that time, they reported to Mr. Webster, is that right?
Yes. Starting on October 5th, 2020, they would have been reporting to First Assistant Brent Webster.
And would those staffers be required to comport with OAG policies in their interactions and their work for First Assistant Webster?
Yes.
And that would be a reasonable expectation that Mr. Webster would have of them?
Yes.
Let's talk about Ryan Bangert. Do you recall what his title was?
Ryan Bangert was the Deputy First Assistant Attorney General.
And how did his employment at OAG conclude?
Mr. Bangert submitted a letter of resignation on approximately, I think it was October 28th, 2020, and then left the agency as identified in the letter on November 4th, 2020.
And what about Darren McCarty? How did his employment at OAG conclude?
Darren McCarty was the Deputy Attorney General for Civil Litigation, and Mr. McCarty submitted a letter of resignation on, I believe, October 26th, 2020, and then left the agency pursuant to the letter he left on November 4th, 2020.
And what about Blake Brickman? Do you remember his title?
Mr. Brickman was Deputy Attorney General for Policy and Strategy.
And how did his employment at the office conclude?
Mr. Brickman was involuntarily separated.
Mr. Arroyo, could you please pull up AG Exhibit 224? And Your Honor, I'm going to move to admit this exhibit. I understand from counsel during the break that there is no objection.
No objection.
The exhibit shall be, what was the number again?
AG 224.
224, admitted to evidence.
Mr. De La Garza, is this memo a memo that you drafted related to Mr. Brickman's employment with the Attorney General's office?
Yes.
And does this memo reflect advice that you provided to the office related to Mr. Brickman's continued employment and ultimate termination?
Yes, it was advice about if we wanted to write a justification, this could be a draft of a justification.
And is this justification, was this the result of an independent analysis that you made with respect to his employment at the office?
Yes.
Were you instructed by anybody to come to any conclusions regarding his employment?
No.
Could you please explain the conclusion of this memo for the jury?
I only see page 1. I'm not sure.
Your Honor, may I approach the witness, please, with a hard copy?
Yes, you may.
Thank you. Just the conclusion was that involuntary separation, that he could be allowed to resign.
Looking at the memo, at the bottom of page 1, you write that Mr. Brickman has engaged in the following misconduct as identified in the agency's unacceptable conduct policy. Do you see that?
Yes.
And you list a number of violations. Is that correct?
Yes.
And is it true that in this memo you indicate that regardless of Mr. Brickman's report to law enforcement, there are violations of agency policy that justify termination?
Yes. I mean, in many ways, it's just it was a situation of an employee with a new boss and having an insubordinate or unprofessional tone towards the new boss, and not following orders, directives of the new boss.
And based on the information that you were aware of at the time, was it your opinion that Mr. Brickman's had some job performance issues in the workplace following his report to law enforcement?
Yes.
And was part of that misconduct creating an atmosphere that was untenable for the agency?
Yes.
And can you just describe a little bit what that is? I'm looking at page 2 of your memo, talking about the working relationship being strained and inefficient. Could you describe what you were aware of at the time that you made this memo?
Yes. I mean, overall, it appeared that there were some pretty egregious violations of the kind of the insubordinate tone of that policy that you had mentioned earlier. And the insubordinate tone, the demeanor, the language, the refusal to perform directives from the Mr. Brickman's new boss, new supervisor. Just overall, there were those issues really stood out, and then overall, just based on the everything applicable state law, federal law, the facts presented, there was no reasonable expectation that he wanted to work for the new boss, the new first assistant, or no reasonable expectation that.
Objection. Narrative. We just asked for a question and answer, Your Honor.
Sustained.
Mr. De La Garza, you mentioned that Mr. Brickman's behavior was egregious. Did I hear that correctly?
Yes.
And is it your understanding that part of the egregious nature of his behavior was his refusal to meet with his supervisors?
Objection. Leading.
I'll rephrase.
Rephrase. Sustained.
Mr. De La Garza, what was egregious about Mr. Brickman's behavior?
Based on the facts presented to me, that type of insubordinate tone and demeanor is pretty rare in our agency.
Who did you provide this memo to?
I believe I would have probably sent it to my boss at the time, the human resource director at the time, and probably Brent Webster, the new first assistant.
Who, to your understanding, who made the decision to terminate Mr. Brickman's employment?
It would have been, his supervisor was the first assistant.
And did you support the decision to terminate Mr. Brickman's employment?
Based on the facts as presented to me and the applicable state law and federal law, especially about political patronage, yes, there didn't seem to be a reasonable expectation that he could continue working with or for Brent Webster or continue serving as a high-level policymaker for the Attorney General.
And do you stand by the advice in this memo today?
I do.
Okay, let's talk about Mr. Ryan Vassar. Was he the Deputy Attorney General for Legal Counsel?
Yes.
And his employment at the office was terminated, is that correct?
Yes, involuntary separation, yes.
And who made that decision?
That also would have been the first assistant.
Did you support the decision to terminate his employment with the office?
Based on all the facts presented to me and the applicable state and federal law, yes, there was a variety of reasons. There was a lack of confidence in his...
Objection, Your Honor. Hearsay. The witness just testified based on information he received.
Sustained.
Mr. De La Garza, did you provide any recommendations concerning Mr. Vassar's, the involuntary separation?
Yes, as a HR director, I have to rely on information that is presented to me.
Okay, and sorry, I didn't mean to talk over you. When you were providing those recommendations, were you advised by management of some issues, some job performance issues that they were experiencing with Mr. Vassar?
Objection. Hearsay. Advised by management. Out of court statement, Your Honor.
Your Honor, if I may, I'm asking about the facts that inform his recommendation. I'm not offering them for the truth of the matter, but rather for just the things that he was aware of at the time he made his recommendation and why he made that recommendation.
So Your Honor.
I'm going to sustain your objection. Find another way to ask the question.
Thank you, Your Honor. Did agency policy support the decision to terminate Mr. Vassar's employment with the agency?
Yes.
And was it your understanding that Mr. Vassar had violated agency policy by sharing confidential grand jury subpoenas outside of the agency?
Objection, Your Honor. I need to interrupt. This is knowledge gains through hearsay and leading.
Sustained.
Could you please describe what the violations of agency policy were that supported termination?
Well, just overall, as far as the reasons presented to me for separating him were, there's a combination of
Objection,
some-
Your Honor. Reasons stated to me as an out-of-court statement, hearsay.
Your Honor, again, this goes to the basis for his recommendation. This is not he's not testifying as to the truth of it, but rather the information, his understanding of the information and what informed his advice to the agency.
We'll overrule your objection this time.
You can answer the question, Mr. Delegate.
Yes, I have to rely on the facts presented to me. We have 4,000 employees. So with respect to Mr. Vassar, I had to rely on the facts presented to me on what he had done or had not done. And so as far as the overall reasons, there was a variety of reasons, a lack of confidence. There were some issues about his performance, some issues about the handling of grants or mishandling of grants. Overall, there was some insubordinate tone and demeanor, and overall, there was, my understanding, there was one last meeting to see if there was any reasonable expectation that Mr. Vassar could or wanted to work with or for his new boss,
Objection, Your
Webster.
Honor. I apologize for interrupting. Can we keep this question and answer? My objection is narrative.
Sustained.
Mr. De La Garza, let me ask you about that meeting. You mentioned that there was one last meeting before there was a decision made to separate Mr. Vassar from his employment at the office. Were you present at that meeting?
No.
Were you later requested to provide counsel as a result of what had happened in that meeting?
Yes,
And sorry, I'm going to stop you right there just because I want to make sure that we're keeping this question and answer. But I appreciate your testimony. When you were asked for advice, did you ultimately recommend separation?
Yes.
And do you agree with that decision today?
Yes.
Let's talk about Mr. Maxwell. Was he the director for law enforcement?
Yes.
And was his employment also terminated from the Office of Attorney General?
He was involuntarily separated yes.
And who made that decision?
First Assistant Brian Webster.
Did you advise Mr. Webster with respect to that decision to terminate Mr. Maxwell's employment from the agency?
I recommended that it could be done, that it was reasonable based on the facts presented to me.
And did you personally have prior experience with Mr. Maxwell and some violations of agency policy in the past?
Yes.
And how would you how would you describe your experience working with Mr. Maxwell?
I admire all that he's done, but with respect to HR issues, in HR, certainly it was a developing pattern of not going to HR for guidance on some very sensitive HR matters.
And did the failure to go to HR for guidance on very sensitive matters, did that ultimately expose the agency to liability?
It could have.
And about how many instances?
Well, there was one case with a Hispanic peace officer, a female, who had been subject to sexual harassment.
Objection, Your Honor. This is knowledge gained through hearsay. Presumably, he did an interview with this woman who will not come in to testify. All of the information he gathered and he's relaying to us is hearsay.
Your Honor, I'll move on.
Sustained. Continue.
I'd like to offer what's going to be marked as AG Exhibit 1055. I understand counsel does not have an objection to this either.
No objection, Your Honor.
Admit 1055.
And Your Honor, may I approach the witness with a hard copy? Thank you. Mr. Arroyo, could you please pull up AG Exhibit 1055? Mr. De La Garza, do you recognize AG Exhibit 1055 as an email that you drafted to Brent Webster and Aaron Reitz?
Yes.
And does this memo provide your legal advice regarding the continued employment of these staff members?
Yes.
What prompted this email?
Mr. Maxwell and Mr. Penley, Mr. Maxwell and Mr. Penley had been on investigative leave, and they wanted to have a meeting to see if there was any reasonable expectation that they could work with or for Brent Webster.
And I'm sorry, Mr. De La Garza, just for the record and for clarification, when you say they wanted to have a meeting, who is they?
Well, primarily the first assistant, Brent Webster.
Thank you, and I'm sorry to interrupt. Please go on.
And there was this kind of a sort of a last ditch, let's see if there's any reasonable expectation that they could work with or for Brent Webster, the new first assistant, and whether there was any reasonable expectation that they could continue as high-level policymakers with Attorney General Ken Paxton.
And so is this email your suggestions of things to ask in those meetings?
Yes.
Why did you pick these particular questions, like, do you trust me? Do you trust the Attorney General? Are you committed to the vision? Why did those questions make it into this memo?
Well, based on the case law, Elrod v. Burns, Branty v. Finkel, and its progeny, that's what you focus on: the loyalty, trust. Can the elected official, trust the people that he's or she is chosen to support their vision, their goals.
And why would that be important to the agency?
Well, it's definitely a question about efficiency. I mean, you want everything to move along, and if his deputies aren't, if they're not seeing eye to eye, it's going to break down, and then it eventually starts trickling down, and we start losing, efficiency, and there could be worse problems.
Mr. Arroyo, could you please pull up House Managers Exhibit 383? And, Your Honor, this is already in evidence. May I approach the witness with a hard copy? Thank you. Mr. De La Garza, do you recognize this email that was sent by Greg Simpson, your former boss, to Brent Webster copying you related to the CID division?
Yes.
And I don't want to go through this whole thing, but I just want to ask you, on the second page, could you please read aloud the last two sentences on the last page of this document?
It reads, overall, HRD has had difficulty getting CID to work with us on matters that are appropriately and exclusively within HRD's authority. Maxwell's actions have exposed the agency to potential liability.
And what does HRD and CID, what does that mean?
HRD would be the Human Resources Division, and CID would be the Criminal Investigations Division.
And the Criminal Investigations Division, that was the division that Mr. Maxwell was chief of, correct?
Yes, that's one of the primary divisions under law enforcement, under his purview.
And so does this email identify a number of issues with Mr. Maxwell's management of his division?
Yes, Mr. Simpson explained that there were some challenges that HR had faced.
Did you agree with the decision to terminate Mr. Maxwell's employment with the agency?
Yes, based on the facts presented to me and the applicable law, it seemed reasonable.
And, okay, you can set that aside. Thank you. Do you agree with that decision today, Mr. De La Garza?
I do.
And who made that decision?
That would also have been the first assistant, Brent Webster.
I'd like to talk to you about Mr. Penley. Do you recall that he was the Deputy Attorney General for Criminal Justice?
Yes.
And he was also involuntarily separated?
Yes.
Was he offered the option to resign?
Yes, he was.
And to your knowledge, before Mr. Penley was let go, did he meet with Brent Webster?
Yes.
And did he have the meeting that you suggested or that you mentioned earlier about whether there could be a reasonable expectation that Mr. Penley could work effectively with the new first assistant?
Yes, that meeting took place.
And what was your understanding about the prospect of Mr. Penley being able to effectively work with Mr. Webster following that meeting?
My understanding from that meeting it was that there was no reasonable expectation that Mr. Penley wanted to work with or for his new boss, First Assistant Brent Webster, that he could in the future, and that he could serve as a high-level policymaker for Attorney General Ken Paxton.
Did agency policy support Mr. Penley's involuntary separation?
Yes.
How so?
Well, just based on the lack of confidence, there was some evidence of questionable decision making, just the breakdown in the working relationship. There may have also been, from what I recall, some insubordinate tone or demeanor towards Brent Webster. And so just overall, based on the applicable state and federal law and the facts presented to me, it seemed reasonable, and the policy supported that.
Was it also your understanding at the time that Mr. Penley had omitted some material information in a court filing?
Yes, that had been also presented to me as far as some wrongdoing, whether it was misconduct.
I apologize for interrupting. This had been presented to me as hearsay, out-of-court statement. We object to hearsay.
Your Honor, this is the same ruling that you made earlier to overrule the objection. This is the facts that were presented to him that informed his advice to the agency and that was subsequently conveyed to Mr. Webster, who determined what the employment decisions would be going forward.
Your Honor, if I may.
Overruled.
You
Yes,
may continue.
I'm sorry. What was the question again? I'm sorry.
Yes, the question was whether it was, you know what, I think you answered it. Thank you, Mr. De La Garza. I will ask you a follow-up question. You said it was your understanding that facts had been presented to you that Mr. Penley had omitted material information from a court filing. Is that right?
Yes, that was the facts presented to me.
And do you know whether that constitutes a violation of the agency's policy on handling confidential and privileged information?
Yes, we have a specific policy on that.
And did you agree with Mr. Webster's decision to terminate Mr. Penley's employment?
Yes, based on the law and the facts presented to me, it was a reasonable decision.
And sitting here today, do you stand by that support, that recommendation?
I do.
Mr. Arroyo, could you please pull up AG Exhibit 120? And Your Honor, this is not in evidence, so I'm going to offer it now. I understand that counsel does not have an objection.
No objection.
Admit AG 120 into evidence.
And Your Honor, may I also approach the witness with a hard copy?
Yes, you may.
Thank you. Mr. De La Garza, do you recognize this email?
Yes.
And does this email reflect some of the legal advice that you provided to the agency, including to Mr. Webster, about the application of the Whistleblower Act?
Yes, I provided some what I considered privileged and confidential advice regarding the petition that had been filed.
Understood. Mr. De La Garza, looking at the first paragraph of this email, you write, "Here is my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection." Do you see that?
I do.
And I want to ask you about that term, high-level policymakers. What does that, why was that important?
That is the term used in sort of political patronage case law about, that elected officials can appoint. They have to be high-level policymakers for them to be appointed.
I'm sorry, they have to be high-level policymakers to be appointed. Is that what
Yes.
you said? Thank you. And all of the former staffers who made reports to law enforcement, in your view, fell under the category of high-level policymakers.
Objection, leading.
Your Honor, I'm just clarifying his testimony, but I can restate.
Sustained, just restate it.
Mr. De La Garza, is it your opinion that the former staffers who made reports to law enforcement were all high-level policymakers?
They were high-level policymakers.
And could you just summarize for the jury some of the points that were important to you here that led you to your conclusion that they constitute high-level policymakers that are exempt from the Whistleblower Act?
Well, based on the list that I have here, and it was supported by case law, they required more than simple ministerial competence. They created or implemented, agency goals, policy. They controlled or exercised a role in the decision-making process as to the goals and general operating procedures of the agency. They ensured that policies which the electorate had sanctioned by electing the Attorney General were effectively implemented. They all had access to confidential documents or other materials that embody policymaking deliberations and determinations. Party affiliation was an appropriate requirement. They served as
Sorry, Mr. De La Garza, if I could, I just want to stop you there at the bullet point about party affiliation. You write here that party affiliation was an appropriate requirement for effective performance of the public office involved. Is party affiliation something that the agency would look for in the employees who apply for competitive jobs in regular postings?
No.
Mr. De La Garza, do you stand by this advice in AG Exhibit 120 today?
I do.
Thank you. You can set that aside. Mr. De La Garza, did the Office of Attorney General have legitimate, non-retaliatory reasons for terminating these staffers' employment?
In my opinion, yes.
And under the Texas Whistleblower Act, can the Office of Attorney General or any state agency terminate a whistleblower based on information or evidence that is not related to their whistleblower report?
Yes.
And do you agree that that for the agency to be effective, that high-level policymakers need to be able to collaborate effectively with the First Assistant and with the Attorney General?
Yes.
Did you believe that there was any reasonable possibility that any of these former staffers could do that?
Well, Darren McCarty resigned. There could have been Ryan Bangert. I would say that there was possibly with them, but
for the ones that resigned, but for the ones that were terminated, was there a reasonable expectation that they could work with the new First Assistant and with the Attorney General?
Yes. For the ones who were involuntarily separated, no, in my opinion, there was no reasonable expectation.
Did Ken Paxton ever indicate expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Do you have any knowledge that Brent Webster ever indicated expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Did anyone at the Office of Attorney General determine what your recommendations would be with respect to the legal advice you provided for these former staffers who were involuntarily terminated?
Not to my knowledge.
Was your analysis of whether the former staffers had violated agency policy, was your analysis an independent analysis?
Yes. I mean, at times I consulted with the other lawyer, my boss, before he left.
Mr. Arroyo, could you please pull up Article of Impeachment 6? And could you turn to the next paragraph of Article 6, please, Mr. Arroyo? Mr. De La Garza, Article 6 accuses the Attorney General of terminating the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Do you see that?
I do.
Is good cause required to terminate an employee in Texas?
No, it's not. But at the Attorney General's office, we ensure that there are good reasons and that it's fair.
And did good reasons and fair reasons exist for each of the former staffers that were involuntarily terminated?
In my opinion, yes.
Is due process required to terminate an employee in Texas?
No, there's no property right to our jobs since we're at will. So due process, there's no constitutional right, and but we ensure that it's fair.
So, okay, thank you. And were any of the former executive administration staffers terminated in retaliation for making a report to law enforcement?
In my opinion, no.
Thank you, Mr. De La Garza. I pass the witness, Your Honor.
Thank you. Your witness. Please state your name for the record.
Yes, Your Honor. Yes, Your Honor. Daniel Duco. Hi, Mr. De La Garza. How are you?
Fine, thank you. How are
Mr.
you?
De La Garza, you testified a moment ago that you are familiar with the Texas Whistleblower Act, correct?
Yes, I did.
And you understand that the Texas Whistleblower Act affords protection to people that go to law enforcement so they can go to law enforcement without retribution, right?
Yes.
And as part of the Texas Whistleblower Act, that protection only extends to people who still have their job.
Yes, they are, yes.
Right, so what I mean is, if you report someone to law enforcement and they still have their job and then they're retaliated against, they are protected by whistleblower, correct?
If they comply with the retaliatory, the requirements in the Texas Whistleblower Act, yes.
But if they get fired before they go to law enforcement, they're not afforded the protection of the Whistleblower Act, correct?
Right, it has to be, right.
Right, so before you go to law enforcement, you don't want to tell your boss, I'm going to law enforcement.
Objection, speculation.
Sustained.
Under the Whistleblower Act, if you tell your boss you're going to law enforcement, you get terminated, then you go to law enforcement, you're not entitled to the whistleblower protection, correct?
Objection, speculation. It's the same question, Your Honor.
Just said he knew this.
You can answer if you know.
All right, could you just repeat the question, please?
Sure. Under the whistleblower statute that you said you're familiar with, if you tell your boss, I'm about to go to law enforcement, then before you go to law enforcement, you get fired, then you go to law enforcement, you're not entitled to the protections of the whistleblower statute, are you?
I guess you could make the argument in court. I'm not sure how successful you'd be.
But you agree with my statement, correct?
Probably wouldn't be the best way to do it.
So if someone were to stand up here over and over,
Witness needs to speak up when you speak.
Oh, excuse me.
if someone were to stand up here over and over and say, why didn't you just call your boss? Before you went to law enforcement, why didn't you just call your boss? Under the Whistleblower Act, that wouldn't be a good idea, would it?
I mean, if your plan was to file a lawsuit, then yes, you shouldn't do that.
You should not go to your boss first.
If you were planning to file a lawsuit, I mean, it depends on the situation.
I'm not talking about a lawsuit. I'm talking about whistleblower protection. It would not be a good idea to call your boss first, right?
Objection, asked and answered.
Overruled.
Right?
You're asking me to speculate. I'm not sure what a plaintiff should or shouldn't do.
You don't want to answer that, do you?
I'm not here to, speculate as to what a potential plaintiff under the Whistleblower Act should do or could do.
Just so we're clear, you're not here now. A moment ago, you were okay with it, right?
Objection, Your Honor. It's argumentative.
Sustained.
All right, let's put up AG 120, please. Can you see AG 120?
Yes.
This is a document that you created, an email, right?
Yes.
And in this email, it says, here are my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection, correct?
Yes.
This is your analysis.
This was a privileged and confidential document that we are brainstorming.
I appreciate that, but I think I wrote down your words, and what you said was, this is my analysis. You still stand by that?
Sure.
And you said, I stand by that today.
Yes.
And you said to the senators here, this is the correct analysis, right?
At the time, I believed it was the correct analysis. So
This argument, this exact argument that's in this document right here, was made in the court, right?
I'm not sure. I wasn't involved in that.
You're not familiar with the Court of Appeals case, Office of the Attorney General versus Blake Brickman, Mark Penley, David Maxwell, and Ryan Vassar? You're not familiar with that?
I'm familiar, but I wasn't involved. I didn't work on that appeal.
Are you familiar with the decision that came out in that appeal?
I would have to read it, and
You don't remember?
to be honest, I'm not sure if I carefully, that was not something that I needed to read.
Well, if you had read it, you would know that the Court of Appeals said all of your analysis in AG 120 was wrong.
Objection, argumentative.
Right? He knows,
Overruled.
right?
It happens as lawyers, we make arguments and courts don't agree with them. And so, there's always going to be a winning side and a losing side. And at the time, I was just coming up with potential arguments. That's what, we do.
Right, so when the senators are deciding whether or not this is a valid argument, they can disregard it because the Court of Appeals already decided it was not.
Objection, this misstates testimony and is going outside of direct. This also is talking about a document that is not in evidence, and there's been no testimony before this witness about.
Overruled.
Right?
I defer to the Senate to do the right thing.
You spent a lot of time telling us about how people were involuntarily separated. That means fired, right?
Yeah, we just like to use involuntary separation.
Okay, I just want to make sure we're on the same
Yes.
page. That means fired.
It does.
You also spent a lot of time using the phrase, based on facts presented to me, right?
Yes.
And those facts were presented to you by Brett Webster.
For the most part, yes.
Doesn't it seem like you had a Brett Webster problem?
Well, he was the new first assistant, and these employees were reporting to him.
I mean, you've heard the term garbage in, garbage out, right?
I've heard the expression.
So if Brett Webster is giving you information that's not true, then your analysis is wrong, correct?
I I have to rely on the information given to me.
I appreciate that. My question is a little bit different. If Brett Webster's not telling you accurate information, then all the analysis you gave on direct examination is all incorrect.
Objection, speculation.
He knows.
Overruled.
Correct?
I have to rely on the facts presented to me, and so
Is my question difficult?
it's, you're saying that if he presented false, if he presented false information to me, and I'm using that false, yes, it could affect my analysis.
Well, let's talk about the real reason why these people got fired. Stacey, can you put the timeline up, please? I'm going to use this for demonstrative purposes, so...
Your Honor, I'm going to object. I've never seen whatever this is before. Counsel and I discussed exhibits during the break. This was not provided to me, so I would request that we get a copy of whatever this is to quickly review.
Not an exhibit, Your Honor. Simply demonstrative purposes, not going back based on dates that this witness provided on direct examination. If the dates are wrong, counsel can correct me.
Well, Your Honor, I mean, we might have an objection to whatever he's going to put on this timeline. I don't know what it is, and I don't have an opportunity to verify it, and it's being published to this jury as if it's fact. So I'm going to object to displaying this to the jury.
Your Honor, they're making evidentiary arguments. I'm not offering this into evidence. It's purely demonstrative.
Your Honor,
Hold on. Don't talk over each other. I think you can provide the counsel with what you're about to show. Yes.
Thank you. Your Honor, I might have objections as this goes along because I don't think there's any foundation that he's laid yet, at least, to ask to publish these as something that's within this witness's personal knowledge. But subject to that, I appreciate counsel providing this copy, and we can move along.
Move along.
Mr. De La Garza, on September 30th, and just before we get started, I want to point out this timeline is a...
Yes.
Stay at the microphone.
Yes. I want to point out, Mr. De La Garza, that this timeline is roughly a month and a half, less than a month and a half. Do you see that?
Yes.
And as you are familiar with the whistleblower statute, as you testified in direct examination, I'm sure you're familiar with 554.004, right?
Could you remind me?
Sure. It says, in an adverse action, if within 90 days of reporting to law enforcement, there's a presumption of retaliatory conduct.
There is a presumption that can be rebutted.
And so the law says, if within 90 days of reporting something to law enforcement, you're terminated or have an adverse action, we are to presume that was retaliatory, right?
There's a presumption.
So, September 30th, the whistleblowers go to the FBI, right?
I'm not sure. I have no personal knowledge of what they did.
The head of HR, you don't know?
That's what I heard. That's what they presented to my boss, a letter saying that they had gone there.
Well, let's start over. You're the head of HR, right?
Now, yes.
You know that they went to FBI on September 30th, right?
I have received information that they did. I have no reason to disbelieve that.
You also know on October 1st, the whistleblowers notified HR and the AG Paxton of the FBI report, correct?
Yes, I believe it was the first.
The next day, Mark Penley and David Maxwell were placed on administrative leave.
That's correct.
On October 13th, David Maxwell made his formal complaint against Ken Paxton.
I'm not aware of exactly when he did. Formal complaints go to the formal complaint officer, so if you say it was the 13th. But
you spent a lot of time telling us about David Maxwell. You reviewed all the file. You're telling me you don't know when David Maxwell made his formal complaint?
I don't have personal knowledge of that because formal complaints go to the formal complaint officer. They don't go to HR.
Well, we can assume by the fact that your lawyer hasn't stood up and objected that that's the day he made his formal complaint, okay?
No reason to disbelieve that.
October 15th, Brickman, Vassar, Bangert, McCartley, and Penley all file formal complaints. You know that as well, right?
I understood that they all filed formal complaints.
October 20th, so 20 days after going to the FBI, 19 days after the whistleblowers notify of the fact that they went to the FBI, Blake Brickman was fired, right?
Yes.
Lacey Mace was fired.
Yes.
November 2nd, a month after going to the FBI, David Maxwell was fired.
Yes.
November 2nd, a month after going to the FBI, Mark Penley was fired.
Yes.
November 17th, 6 weeks after going to the FBI, Ryan Vassar is fired.
Yes.
Have you ever heard of the expression, there's no coincidences in Austin? Pass the witness.
Redirect.
Just briefly, Your Honor. Mr. De La Garza, did agency policy support the termination of Lacey Mace?
Yes.
And did you recommend that termination?
I did.
Do you stand by that recommendation today?
I do.
No further questions, Your Honor.
Are you,
No need for it.
okay, we can excuse the witness?
Yes, Your Honor.
Yes? You may step down, thank you. Little housekeeping before the next witness. I said that after the break, I would admit 702 into evidence. We did not do that, so 702 is admitted into evidence. Mr. Donnelly, I think that was the correct number. Also, if both parties would like to come to the bench for a moment.
And we've been listening to testimony from another top executive within the Attorney General's office. His name is Henry De La Garza. One of the things that clearly became apparent is that he was brought in by Team Paxton, by Ken Paxton's defense team, to talk about his testimony is that agency policy within the Attorney General's office supported the terminations that Ken Paxton made of those whistleblowers. So Ashley, his testimony really speaking to whether or not Ken Paxton retaliated against those employees for going to the FBI in September, October 2020. But one of the things that was noteworthy as part of the cross-examination, you could see that the House Management Prosecution went at the fact that his assessment was based on, his written assessment was based on information that was provided to him by Paxton's new first assistant, Brent Webster, who was impaneled in that second highest level position within the agency after Jeff Mateer resigned, as all of this was sort of getting into motion.
And we've heard various accounts of the contentious and almost at times rude, dismissive, disrespectful interactions the whistleblowers and non-whistleblowers, because Brandon Kamick had with Webster. And so this directly speaks to Article 6, which is the termination of the whistleblowers. Ken Paxton accused of excuse me, we're hearing the Lieutenant Governor call the court back to order. We certainly want to hear who this next witness is.
Members of the jury, there was a motion filed yesterday by the House to amend the rules to collapse a vote into one vote. That motion has been withdrawn. Will the defense call their next witness?
Defense calls Grant Dorfman to the witness stand.
Please bring in Grant Dorfman.
Grant Dorfman is being called as the next witness. He was hired, according to a news release I'm looking at right now, in December 2020. Actually, he joined the agency as the Deputy First Assistant Attorney General. He's a graduate of Yale Law School, previously clerked in the Fifth Circuit Court of Appeals, worked in a commercial litigation firm, served as a judge in Houston, a number of different positions he held prior to taking this leadership role within the AG's office.
Yes, and so this would be, he was thereby appointed to basically Paxton's second in command with that title of Deputy First Assistant Attorney General. And again, we've been hearing members of the office talk about the report that was prepared, you know, the validity of that report, if it was a sham investigation, and the firing of the whistleblower. So this is Anthony Osso for the defense who's up questioning. Let's listen in.
Thank you.
Your witness.
May I proceed? And it's Anthony Osso, O-S-S-O, on behalf of Attorney General Paxton. Sir, would you please state and spell your name for the record?
It's Grant Dorfman, G-R-A-N-T. Dorfman is D-O-R, F as in Frank, M-A-N.
Okay, and I understand you're a judge, but just to keep the record clear, I'm going to call you Mr. Dorfman if that's all right.
I appreciate that.
Okay. Mr. Dorfman, could you please tell these senators how you're currently employed?
I'm the Deputy First Assistant at the Office of the Attorney General.
Okay. And I'm going to ask that you lean into that mic and speak loud and clear so that everybody in the courtroom can hear you. Now, before we talk about your role as the Deputy First Assistant, I want to talk to you a little bit about your background and who you are. Can you tell us where you're from?
Grew up in Dallas, Texas.
Okay. And where did you end up going to school?
Brown University in Providence, Rhode Island.
Okay. And then, was that for undergraduate?
Sorry?
Undergraduate?
That was my undergraduate, yes.
Did you go on to do law school?
I did.
Okay. Can you tell us where you went?
Yale Law School.
And what did you do after you completed your time at Yale?
I accepted a clerkship with a federal judge in Houston, Texas, brought me back to Texas after 10 years on the East Coast. I also took 2 years out before law school, got a graduate degree there, not in England as well, and then had a 1-year clerkship opportunity in Houston. Thought I was going back to D.C. to join the Department of Justice for the second term of the George Herbert Walker Bush administration. That never materialized, so I ended up blessedly staying in Houston.
Okay, so after that didn't work out, what did you end up doing next?
I went to work for a commercial litigation boutique and continued in that line. Went to a second firm where I made partner in, I think, 1999.
Okay, which firm was that?
Ogden, Gibson, White & Brooks, and the first firm was Sussman Godfrey.
Okay, and while you were working as a partner, can you describe to us kind of what type of law you were practicing?
Commercial litigation, generally that's a big area, but civil trial work and appeals, and a lot of energy work, a lot of employment cases, and just the things that Houston trial practice is made out of.
Understandable. What did you do after you spent your time working as a partner at the law firm?
Well, I had a desire for government service. I'd never really set it out to be a partner at a law firm and continue that for the last 30 or 40 years of my career. So I'd applied to the Department of Justice when the George W. Bush administration came around, went up to interview for 2 vacancies in deputy AGs in the civil division. I ended up withdrawing within 1 week of the interview because my daughter was on the autism spectrum disorder. She was then 4 or 5 years old. And it turns out, to my surprise, but after exhaustive research, the school she was in Houston did not have any counterpart, any comparable service in either the Washington or Baltimore metro area. So I had to withdraw from consideration for that. That lit a fire under me, reminding me that's kind of what drew me to the law in the first place.
Okay.
And so...
let me stop you real quick. So that's back to Houston, right?
I'm still in Houston.
Okay.
Never left. But then I put in for an application to Governor Perry's office for 2 district court vacancies in 2002.
Okay. And can you tell us what happened with that application?
It was successful.
Okay.
I was appointed to the 129th District Court in Harris County. It's a civil district court in May of 2002.
Okay. And can you tell us what happened after that term and farther on in your career?
I'm sorry, I didn't catch that last part.
After you served as a judge, a civil court judge in Houston, what did you do next in your career?
Oh, well, involuntarily, the voters decided in 2008 that they liked President Obama better than the rest of the ticket. I went in-house with Neighbors Drilling as an independent oil and gas contractor, I should say, with worldwide operations based out of Houston with about 25,000 employees and managed their civil, all their litigation.
Okay. And then at any point did you serve another term as a judge in Houston?
Got remarried in 2013, wanted to do something different, and reapplied to Governor Perry for a district court bench and was appointed in November of 2013 to the 334th District Court, also in Harris County, same kind of court I'd presided over before.
Okay. And so in total, about how long did you serve as a judge?
I think altogether 10 years,
Okay.
not including visiting judge service afterwards.
Okay. And then at some point, you become Deputy First Assistant at the Attorney General's office. Can you talk to us about what took you from Houston to Austin for that job?
Yeah, not to dwell on bad news, but in 2016, I, along with most of my Republican colleagues on the bench in Harris County, lost. And I went back in private practice for a couple years. My father passed in that time frame, and I stepped into a family business that needed more care than I could give it as a full-time litigator. So I juggled that with having left the law firm, being a mediator, an arbitrator, available to parties to resolve their disputes, and also a visiting judge when the administrative presiding judge in Houston appointed me to service in that capacity.
Okay. So what brings you to the Attorney General's office then? How do you go about applying for that job?
Well, it came sort of out of the blue. I had a call from my friend Austin Kinghorn, who I'd known for several years as a law clerk to one of the justices on the Supreme Court, and before that on the Court of Appeals. And he asked if I knew anyone who might be interested in working for the Attorney General. And I said, yeah, me.
Okay. I want to talk to you about that. It's no surprise we're here because there have been a lot of allegations made against Attorney General Paxton. You're aware of this, I assume?
Sure.
So when you get that call from Austin Kinghorn, you're interested in the job. Were you aware of all these allegations at the time?
Yes.
Okay. And can you talk to us a little bit about how you became aware of what was going on?
News reports, as
Okay.
probably most others did.
Was that concerning for you?
Yes, it was.
Can you talk to us a little bit about the concerns that you had after reading the news reports?
Well, I knew the reason they were calling and looking for people was because they had openings, and that was the good news. The bad news was these were serious allegations, serious charges that concerned me. And when I did go up to interview in Austin, and for that reason, probably unlike any other interview I've had, I took special time to press, in this case, First Assistant Brent Webster, on these charges.
What were your main...
Normally the interviewee is the one trying to sell him or herself.
You had to cross your T's and dot your I's. Can you talk to us about what your main concerns were coming into the Office of Attorney General?
You might be less interested in this, but I had kids at the time in high school and in junior high, so commuting back and forth to work was a concern. Where to live in Austin, it's not cheap, was a concern as well. So those were, I think you're asking something else.
Well, that's a fair concern, but I am also interested, legally speaking, you're walking into an office where the Attorney General himself there have been allegations made to the FBI.
Sure.
And so what about that was specifically concerning to you in that situation?
Well, as I said, I spoke with Brent Webster when I interviewed, and I was much more pointed and brusque than I would normally be when I'm trying to get the job. And I knew he was a prosecutor, and by all accounts, a good one. So I pulled no punches. I pressed him, asked what I thought were fairly pointed direct questions as to, okay, this is the allegations I'm seeing in the paper. What's the answer to that?
Kind of like a cross-examination a little bit?
A little bit. And it had an evidentiary quality to it as well, because he very patiently, I thought, given the busy nature of the office and the constraints he was under, took the time with me to walk me through the documents he'd assembled at that point.
Okay. Now, after leaving that conversation, can you talk to us about what your opinion was with regard to taking the job as Deputy First Assistant Attorney General?
Well, I satisfied myself that these charges were, in my opinion then, not well-founded. I knew as part of my job there were a number of interesting things going on in the office, but I also knew as part of that, like the Google ad tech lawsuit was coming. In addition to that, I'd be in charge of defending, I think it was then pending, the Whistleblower Act lawsuit involving these charges. So that was also a concern.
Right. So I assume you take the job because we're here right now.
I did.
All right. And I want to talk to you about, well, when exactly was it that you started as the Deputy First Assistant?
December 3, 2020.
Okay. So that's after everything kind of went down with regard to October and the reports to the FBI, right?
Yes.
You mentioned that you were a part of ultimately the whistleblower suit. Are you aware of reports that were drafted within the office?
Yes.
How many reports were there?
2.
Can you distinguish the 2 different reports that were drafted on behalf of the Office of Attorney General?
Yes, the first one started almost from the time I was there. The first I remember seeing a draft was sometime in January, I think early January, because I was still working from home right after the holiday. I remember that going through edits of 2021. And that was released by our office in August of 2021, publicly on our website.
Okay.
And that detailed the main whistleblower allegations and what our office, after forensically collecting documents, emails, exhaustively compiling everything, was able to put together to address these allegations.
And can you tell us who actually authored or published that report?
The Office of the Attorney General.
Okay. Now, is it safe to call that the internal report?
Yes.
Was there a secondary report that was drafted?
Yes, and if you have a copy, that would help me be clear and precise, but I believe it is on Louis Brisbois' letterhead or in the format of a memo to the Office of the Attorney General.
Objection, Your Honor. Testifying from a document not in evidence, testifying about a document not in evidence, and hearsay.
Thank you.
Sustained.
There's a report in existence, correct?
Same objection, Your Honor.
There are 2 reports.
He's not testifying with regard to what is stated in the document.
Overrule that. Go ahead.
Okay. There is an existence of a Louis Brisbois report, correct?
Yes.
All right, we'll get there. But before we do, I want to be very clear. You started in December of 2020, right?
Yes.
You've looked at both of these reports, the internal report and the Louis Brisbois report, right?
Objection leading, Your Honor.
Show only to lay a foundation, Judge.
I'm going to sustain, just,
Yes, Judge.
ask the questions one at a time.
Certainly. Are you aware of
It's hard for me not to rule, by the way.
Are you aware? It's in their allegation, so I'll talk about it. Are you aware of the 2 reports?
Yes.
Have you read the 2 reports?
Yes.
Now, were you present at the Office of Attorney General during any of the subject matter involved in those reports?
I want to answer no, and I think that's right, but I would have to look at the reports to absolutely confirm. But I think everything that was detailed in both reports predates December of 2020.
Sure. Well, let me be more specific. Are you aware that the Office of Attorney General was involved in an open records request involving Nepal?
Historically, I'm aware. I wasn't there at the time.
Are you aware that they were involved in litigation with the Mitty Foundation?
Yes, again, historically.
And are you aware that there was an informal guidance letter with regard to non-judicial foreclosures?
Yes.
Now, were you present at the office during any of those events?
No.
Were you present at the office during the hiring of Brandon Kamek?
No.
So is it safe to say that you don't have personal knowledge of any of those events that are authored in the reports?
Yes.
All right. Give me one sec, Judge. I intend to get an exhibit for the witness. Mr. Dorfman, would you take a second to look at a copy of my exhibit numbers cut off? Attorney General Exhibit 23, and let me know whether you recognize the document.
I have looked at it and I do recognize it.
What is this document?
This is what you're referring to as or referred to as the Lewis Brisbois report, the second report in time that our office released on these matters. Well, I say our office, this was outside counsel sending it to the office.
Okay. And is this a fair and accurate copy of the report issued by Lewis Brisbois on behalf of the Office of Attorney General?
Near as I can tell.
At this time, Judge, I would offer Attorney General Exhibit 23.
Your Honor, there's so much hearsay in there, I don't know where to begin. The document itself is hearsay. Within this document are conversations between people that are out-of-court statements that are hearsay. It relies on documents that are out-of-court statements that are hearsay. It also relies on people talking to other people who talk to other people, which is 3 layers of hearsay. So my objection, Your Honor, is hearsay squared.
Sustained.
Judge, may I respond briefly? My understanding, and Mr. Arroyo, if you would pull up Article 7, please. My understanding is that the House Board of Managers' allegation in this case is that Ken Paxton and the Office of Attorney General issued a report that basically alleged false and misleading facts. This is a legally operative document in this case.
Your Honor, may I respond?
And the House doesn't want it in evidence? I don't understand how they can argue it's a lie if it's not even in evidence before the jury.
Your Honor, I hope counsel is not trying to mislead this court because this article of impeachment is based on the internal AG report. This report, the Lewis Brisbois report, came out after the article of impeachment. And so I'm sure counsel would like to retract his statement and not mislead this court. Regardless, this is so much levels of hearsay, and this thing up on the screen doesn't get around that.
I don't wish to retract my statement at all. I don't think that the allegation is necessarily clear, and I'm going to continue to argue that this is a legally operative fact.
I would suggest as an officer of the court that he retract it because this report has nothing to do with this article.
Come forward, gentlemen.
Thank you, Your Honor.
In case you're watching, it's Daniel Dutko. He is an attorney with Rusty Hardin and Associates. That who is for the prosecution is arguing that basically there were 2 reports prepared related to the whistleblower claims. Tony and I, we actually talked about this earlier. There's a report that was prepared by the AG's office, staff in the AG's office, and then
There was
the AG's office hired
quote unquote outside report.
Right, that the AG's office hired a law firm to then do a separate report, and
Both of which absolved Ken Paxton of wrongdoing.
right. And the point that, the prosecution is trying to make is, well, this other report is not related to any of the articles of impeachment. In fact, Ken Paxton was impeached before this article was ever even before this report was ever even released. And so why would we look at this and take it to be fact, right? So that's the other thing, is that they're trying to present it as fact.
And again, we're seeing the attorney for the House impeachment managers essentially stop short of calling, Anthony Oso, suggesting that he's misleading, that he is making statements that he is encouraging him to take back. So very, very interesting sparring there between Anthony Oso and Mr. Dutko from Rusty Hardin's firm there in Houston.
Of course.
On the stand, by the way, is Grant.
Yeah, perhaps we should mention that part.
On the stand, by the way, is Grant Dorfman. He is a former judge in Harris County who, he's done a lot of things. He's got an extensive resume, but one of the things he was a judge in Harris County prior to being hired in December of 2020 for the AG's office.
Let's listen back
Hold on
into
one
the
second.
testimony.
notice. Give a senator a minute and they're gone. We will be taking a break shortly, members, okay? We've just been back 90 minutes and we normally take a break.
Because every time they approach the bench, you do see the senators get up and move around.
Or some of them make a run for it. Keep in mind, I mean, just as we have said many times during the 8 days that this trial has been going on, and that is senators are required to essentially be on the floor in their seats during this entire event.
Right, they are, if they're allowed to, step outside for a moment to a room where the trial is playing still, if they need to get a sip of water, get a snack, relieve themselves, obviously, but they cannot leave the building, they cannot leave,
the
chamber.
Attendance is required.
Yes, it's required, and they themselves wrote that their attendance must be required.
That's right, and
that
voted for it, yep.
Without it. So, as we wait for them to come back onto the floor.
To resume again, yeah.
Is it Senator? Well, that's our photographer, Scott Guest, taking a look. They are allowed to stand up.
Oh, here we go.
But perhaps we were
ready.
waiting for Senator West to come back in. So
Before
let's listen back in.
Oh, and there's Senator Campbell.
And Senator Campbell.
I want to talk to you about your time at the Office of Attorney General in December of 2020. Can you talk to us about what was going on as far as it relates to productivity in the office at that time?
It was a very busy time. I think I mentioned the Google ad tech lawsuit that had been years, as I understood it, in the making. We were about to release the complaint at long last in federal court. It was a huge and extraordinarily complex case. You're taking on Google, so I was told if I took the job, I would have frontline responsibility for, or at least overseeing that, and we intended to hire outside counsel. So that was a big part of that. At the time, of course, the election was still going on. There were still election challenges, and I know people were talking to the office about that. That ended up resulting in the Texas versus Pennsylvania lawsuit. So my first week on the job, I think my first day on the job, we went to lunch.
I'm going to slow you down. I'm going to break that up, Mr. Dorfman. So you're talking about the election. I assume it's the presidential election, correct?
Yes.
Okay. And can you talk about the effect that that had on the workload of the Office of Attorney General at the very beginning of 2021?
Well, I had nothing to gauge it by, but it was extraordinarily busy time.
And did it appear that the morale, that people were working hard at the Office of Attorney General?
Oh, absolutely.
And despite the allegations that were made against Attorney General Paxton, people were still working at the office?
Yes, in my first 2 weeks there, I don't think I made it home before 8 p.m., certainly.
Did you have any, sorry to cut you off, but did you have any concerns about the work pace and workflow at the office?
No, it was fun. I mean, if that had been for the next 2 years, I would have had concerns.
Okay. As far as burnout goes or things like that, were there any concerns about anything like that?
Specifically December 2020?
More into 2021.
Yes, as 2021 went on, obviously the Biden administration came into office. Day one, people may remember this, a raft of executive orders. We were the first, and I'm proud of this, we were the first Attorney General, State Attorney General's office to obtain a preliminary injunction against one of those executive orders. It was the day one immigration order that imposed a 100-day moratorium on deportations, even where congressional statute dictated that removal must take place of a deportable alien within 90 days. And so we challenged that in court, federal court here in Texas, and won. And of course, there were other executive orders that we were challenging and filing lawsuits against. I was a voice in the office from a beginning then, but throughout this time, and as we continue to do the work, that look, it's great to be in court. It's great for our lawyers to go into court at the daytime and spend the whole day and file briefs at night, but you can only do that pace for so long. So I wanted us to be careful, husband our resources, use them wisely, pick the right cases, prioritize appropriately.
Utilize your resources.
To maximize the good work we were doing, I thought.
Now, during that time in fall of 2020, winter 2020, and into spring of 2021, are you guys working in the office or are you working at home at this point? Or is it a mix?
Where I was, everyone was in the office. Now, some of the attorneys in the divisions, the litigation divisions, did a combination.
Okay.
In a lot of the cases, the courts were shut down due to COVID still in many cases. So even though we had cases all over the state, you might have a hearing in San Antonio on this computer in your office, then you turn and have a Zoom hearing in Midland or El Paso 30 minutes later.
Understood. And
Which helps, less travel.
Right. You said that you were Deputy First Assistant Attorney General. Are you aware of who your predecessor in that position was?
I believe it was Ryan Bankert.
Okay. Can you talk to us about your role at the time as the Deputy First Assistant Attorney General?
The core responsibility I had is to oversee the litigating divisions, both criminal and civil. As I'm not a criminal lawyer, never have been, never was a criminal judge for that matter, I rely very heavily on my criminal division deputy, it's Josh Reno, and to manage those responsibilities and report up to me and as needed. But the civil litigation divisions, I feel very comfortable overseeing them. In addition to that, I have overall responsibility at the executive level for policies, procedures. From time to time, I've also had direct report responsibility over human resources, as I do currently, and also over the communications team.
So a wide array of divisions.
Yes.
Now, are you familiar with whether at any point special litigation was under the oversight of your position, Deputy First Assistant Attorney General?
I don't think it has been since I've been there. I think it was at one time. Again, I don't know this personally.
And can you tell us now who oversees the Special Litigation Division?
Ralph Molina.
Okay. And then under Ralph Molina, or at any point in time, was it a Patrick Sweeten?
Yes.
Is he still working that position, moved to a different position?
He's currently our lead counsel in the Buies case in the Rio Grande River, but that's on loan from the governor's office.
Did you have the occasion of working at the Office of Attorney General while he was in charge of special litigation?
Absolutely, yeah. I mean, until I think earlier this year, he joined the governor's office. Up till that point, he was there the entire time I was there.
Okay. Did you feel like you had to help him with his job, or did he appear to be qualified in handling his business in that position?
Patrick?
Patrick.
Very talented lawyer, very experienced, very capable. If I had one criticism of him, it's that he's in court more and managing less. We wanted him to clone Patrick Sweetens, so we had a team of Patrick Sweetens, but Patrick's so good and so natural in the courtroom, I think he longed to be there.
Okay. Do you feel that Patrick is the kind of guy that takes pressure off you if you didn't have to watch the Special Litigation Division?
Certainly. They're the Special Litigation Division for a reason. I think that was a creation of Attorney General Abbott to have the tip of the spear. We have a lot of litigating divisions. We have our General Litigation Division, which are outstanding. All our divisions are very good, do different things. And Special Litigation is you need to be at the courthouse in 30 minutes. We just found out the Obama administration's filed doing this. They've issued that executive order. No time, let's go.
Okay.
And so if I had to oversee that as well as everything else, you're right, it would put more pressure on me.
I want to fast forward and talk to you about the internal investigation report. You said you had no personal knowledge of the contents or the subject matter of that report, right?
Say that again, please.
You had no personal knowledge. You weren't personally there for the subject matter that is in the internal report authored by the Office of Attorney General.
I wasn't there at the time these events happened.
Were you present at the Office of Attorney General when the report was being drafted?
Yes.
Can you talk to us about who was responsible for that, and if you know what process went into drafting that report?
I think in the first instance, we relied on an office-wide forensic compilation of documents, emails, et cetera, that were relevant. Brent Webster took the lead in compiling that, and then we had a team, and again, as early as January, I was editing drafts with others, Josh Reno, later Murtaza Sudarwala, our deputy for legal counsel, legal policy, Austin Kinghorn, Enrique Varela. There were others, but I may have left them out.
Okay. And can you talk to us about what your role was with regard to the publishing of that report, or at least getting the report ready to be published?
Well, I don't think we published it until August of 2021, and that probably is a reflection, one, of just how busy the office was and how much other stuff there was to attend to. But I'm sure I had revised and edited and redlined at least 5 or 6 times the entire document front to back.
Okay. Now, understandably,
And others did as well.
right. Understandably, you weren't present for these events that the document summarizes. Did you play a hand in trying to find documentation to support the positions taken in that report?
More oversaw that process.
Can you talk to us about your oversight of that process?
Yeah, I felt very strongly this had to be, it was going out as a report of the office. I believe the Attorney General had said, look, these allegations are baseless, and I will investigate and present the facts and let the voters decide. Words to that effect. I wasn't there. And so this was a fulfillment of that commitment. I took that as a charge to lay it out there. And I think it's fair to say that the document, my emphasis throughout this process of editing was, look, this needs to be the voice of the agency. It's not any one person. It's all of us, and it's objective. It's factual, both in tone and substance. If we make a conclusion or from the facts that we presented from the documents that isn't supported by the document, let's not make that conclusion. Let's take that out and let the people reading it make their own decisions.
And so really, you're just trying to make sure that they're not making allegations that they can't back up.
Objection, leading.
Sustained.
Would you agree that your job was to make sure that the claims were verified?
Same objection, Your Honor.
Sure. Was it your job to make sure that there was evidence or at least something to corroborate statements that were made?
Was there an objection there?
Not to that, Your Honor.
I didn't think so. Okay.
I certainly viewed that as my job, yes.
All right. Now, you mentioned earlier that at some point you get involved into the lawsuit in this case, and I want to talk to you about the lawsuit, okay? Can you tell us your understanding of when the whistleblower lawsuit was first filed against the Office of Attorney General?
I think it was November of 2020.
Okay. Can you tell us who the named parties within that lawsuit are?
I'm going to struggle on their first names.
No problem.
Ryan Vassar.
Okay.
Mr. Maxwell's first name is
David Maxwell.
David Maxwell. Thank
right.
you.
Mark Penley, ring a bell?
Mark Penley and Blake Brickman. Sorry.
Okay. And more focused on who is the named party or the named defendant in that lawsuit?
There's just one defendant, the Office of the Attorney General.
Okay. Was Ken Paxton specifically named as the party to the lawsuit?
No.
All right. So it's the Office of Attorney General on the filing.
Yes.
And what is the first thing that you all do? Who all is working on the lawsuit with you at this time?
About the same time I was interviewing, I think they were interviewing for outside counsel, so I knew Louis Brisbois had been hired, and either the first or second week we might have had a phone conference or meeting with them. At that point, I think the lawsuit had been amended at least once. There was later a second amended, and so I was working on it. Austin Kinghorn was working on it. The first assistant would have been involved.
How about Chris Hilton? Was he working on it?
I think that's right. I think Chris Hilton was also from the start there. He certainly was later.
Sure.
Enrique Varela as well, who worked with Austin Kinghorn.
And I'm going to cut you off. You mentioned Louis Brisbois. Can you explain to us what Louis Brisbois' job was with regard to the whistleblower lawsuit against the Office of Attorney General?
To be outside counsel, Bill Helfand is an attorney I've known in Houston for at least 20 years. Very good lawyer, specializing in government work, especially defense like Section 1983, federal court lawsuits, many of which, if not most, have an employment quality to them. The sheriff being sued by his deputy, something like that.
And just without getting into the contents of the document that I showed you earlier, the Louis Brisbois report, was that authored by the attorneys that were outside counsel for the Office of Attorney General?
Yes, Mr. Helfand and others.
Okay. Now, in that litigation, did you all file a plea to the jurisdiction?
Yes, we did.
Okay. Can you explain to us what a plea to jurisdiction is?
A plea to the jurisdiction is a document that says to the court, every court must first assess whether it has,
Speaking of the microphone.
Every court must first assess, that was too loud, whether it has jurisdiction to entertain a lawsuit. And the state of Texas cannot be sued for money damages without its consent. And this body and the House are the ones that must expressly waive by statute the immunity from lawsuit, the sovereign immunity of the state of Texas, in order for a plaintiff to recover money damages. They argued, the plaintiffs in this case, that
I'm going to stop you and I'm going to break that down. You know, I didn't go to Yale, so you got to make it slow for me. Mr. Arroyo, would you please put up Article 8 onto the overhead screen? So essentially, plea to jurisdiction, well, let me ask you this. Is that something that is commonly filed in lawsuits in your experience as a civil litigator? Or at least with regard to Office of the Attorney General?
I was going to say, at the Office of the Attorney General, I'd say probably 90% of our defensive cases, at least the ones I'm most familiar with, we file plea to jurisdiction. Almost every case challenging the most recent enactments of the legislature arising out of the last session, which have been, all those legal challenges have been brought in the last few months. We filed pleas to jurisdiction, I think, in every one of those, saying this suit can't go forward, the court has no jurisdiction, the state is immune.
Okay. Now, Eric, if you could just blow up the second paragraph specifically all the way down to, well, this part's fine right here, if you could blow that up. Okay, so I'm just going to read the Article 8 to you, Mr. Dorfman, which states that specifically Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of the facts. The next page goes on to say, and testimony at trial to Paxton's advantage. Sorry.
Let it get up on the screen. Yep. Okay, continue.
To Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. So at what time we know that the lawsuit was filed in November of 2020. When was it that the Office of Attorney General actually files the plea to jurisdiction?
Not exactly sure, but I believe it was January of 2021.
Okay. And when did the Office of Attorney General engage in settlement agreements with the whistleblower plaintiffs in this case?
Almost exactly 2 years later.
Okay. So when we're talking about the plea to jurisdiction, we are 2 years before settlement discussions even come into play, right?
Right.
Now, I think in your motion for plea to jurisdiction, it was in two parts, correct?
I'd have to see it.
Well, did you talk about sovereign immunity?
Absolutely.
Can you explain to us how sovereign immunity comes into play in your plea to jurisdiction?
Well, I think I've covered that. The state is immune from suit unless there's an express statutory waiver from the legislature.
Okay. And then the second part of that was that you talked about separation of powers.
Yes.
Can you talk about that to us?
Well, let me go back and cover the first one, if you don't mind. May I, Your Honor?
If you please go back and cover
I need to qualify my comments. What you're describing is, you've reminded me and refreshed my memory that the Whistleblower Act is exactly the type of express statutory waiver of sovereign immunity that allows one to sue the state, in this case for money damages. But the case law has been clear, and we argued it, that unless you meet all the elements of a Whistleblower Act claim, there is no waiver of sovereign immunity. There's no jurisdiction for the court to proceed. And we alleged that the plaintiffs in the case had not met their burden of establishing all the elements of the whistleblower claim, and therefore sovereign immunity still applied.
Okay. And was that file in the plea to jurisdiction, was that made in good faith and based on your legal research?
Yes.
All right. Now I want to focus back onto the article that states specifically, if you'd go back to the other page, Eric. It talks about, and you zoom in, the settlement agreement stayed the wrongful termination suit. I just want to be clear, when you all filed the plea to jurisdiction, that had nothing to do with the settlement agreement, right?
We weren't even discussing settlement at that time, no.
Okay. Now, what is the result of a plea to jurisdiction with regard to discovery in a lawsuit?
The plea to jurisdiction, again, every court must first assess whether it has jurisdiction. If it doesn't, it's powerless to order discovery or proceed any further. And the legislature has passed an interlocutory appeal so that even if we lose the plea to the jurisdiction, if we win, the case is over and dismissed. If we lose the plea to jurisdiction, we have the right to immediately appeal when normally you would have to wait till the end of a case to file your appeals. And the intermediate appeal stays the court's jurisdiction. It can't proceed further in any capacity until the appeal is resolved.
Okay. Now, was that plea to jurisdiction filed to stop the discovery getting out to the public in this case?
I don't understand your question.
You just said that a plea to jurisdiction essentially stops the discovery from occurring in a lawsuit, right?
It stops anything from occurring in the trial court.
So my question to you is, when you all filed a plea to jurisdiction, did you do so because you felt that the law applied in that situation, or did you do so because you wanted to stop discovery from getting out to the public?
We did it because we thought the state had sovereign immunity, and it was our duty to assert that, as we do in so many of our cases. That does have the effect of stopping discovery from going forward and saving the taxpayers the expense of that discovery and our lawyers the time. That, discovery really is where the time gets taken in trial cases.
Okay. I want to talk to you about the procedural posture of the plea to jurisdiction. Can you talk to us about the first court that ultimately ruled on you all's plea to jurisdiction in the whistleblower lawsuit?
The first court?
Yes.
That was the Third Court of Appeals here in Austin.
Well, did it go to the district court prior to that filing?
I'm sorry. Yes, you're right.
Can you talk to us about that?
We had some discussions back and forth. I don't know how much detail you want to go into, but with the plaintiff's attorneys about scheduling a hearing on two things. They wanted to have a temporary injunction hearing. I think initially they said they needed 4 days. The only purpose of a temporary injunction hearing in this context would be for Mr. Maxwell and Mr. Vassar to seek reinstatement under the Whistleblower Act, so to be reinstated to their position with the Office of the Attorney General.
So are you saying that Mr. Maxwell and Mr. Vassar actually wanted to come back to the Office of Attorney General?
Yes, and I think that's still in their live pleading. Well, they're pleading, I shouldn't say live. Right.
Now, what was the ultimate decision by the district court with regard to that plea to jurisdiction?
Well, so we were trying to schedule the plea to jurisdiction before, 1 week before, something, 1 day, whatever, because the court can't have a temporary injunction hearing until it's heard and ruled on the plea to jurisdiction. The plaintiffs requested and the court agreed to set them on the same day, but that had the effect of meaning before the judge ruled, we were set to a temporary injunction hearing, which got underway and started. And there was even testimony taken, I think, from Mr. Mateer for some time before we got the Court of Appeals to agree that by proceeding with the temporary injunction, she had implicitly ruled, the judge had implicitly ruled that she had jurisdiction. And
so ultimately, and I'm going to cut you off, ultimately the case goes up to the Third Court of Appeals?
Yes.
Okay. So the district court didn't rule on the plea to jurisdiction necessarily?
I'd have to go back and check. I think she may have written an order expressly denying it, but not until after we had already gone up to the third court and said, we need intervention.
Okay. And can you talk to us about what happened at the Third Court of Appeals?
They set oral argument, and I can't remember exactly when that was, but I believe it was October of 2021 when they issued their opinion, maybe 30 pages.
So almost a year later, while that plea to jurisdiction is still pending, right?
Well, the plea would have been filed in January, I think, and so you're talking 9 months later.
Okay. And can you tell us how the court ruled, the Third Court of Appeals ruled?
Third Court of Appeals agreed with the plaintiffs that the trial court had jurisdiction, that our reading of the Whistleblower Act on the two prongs you mentioned was wrong. Well, they disagreed with it.
Okay. And in response to the Third Court of Appeals ruling in that case, what did you all do on behalf of the Office of Attorney General?
We appealed that to the Supreme Court of Texas by filing a petition for review asking them to take the case and reverse the third court's ruling.
Okay. Now, do you recall when the appeal to the Supreme Court of Texas was filed?
Not exactly. It would have been within 30 days, maybe 45 of that October, I think 2021 opinion from the third court.
Okay. And at this point in time, what is going on with the litigation in the whistleblower lawsuit?
Only the appeals process.
Counsel, excuse me, I'd promised a break about 15 minutes ago for the jurors. They've been in a 2-hour sit down.
Now's an okay time
Is
to
this a
stop,
good
Your
time?
Honor. Sure.
I don't want to interrupt, but it's a good time. Members, it's 5 minutes before 4. Come back at 4:15, 20-minute break.
And welcome back, everybody. We have been listening to our third defense witness in the historic impeachment trial. Fourth, excuse me. Yeah, I hesitated.
You keep forgetting about
I looked at you.
This morning,
Yeah, I know.
You've been forgetting about Justin Gordon's testimony this morning. And that's okay. It's nothing personal to Justin Gordon.
Nothing personal. Although I'm not sure his testimony
Exactly.
moved the ball or was
Sure.
particularly memorable.
Sure. So Justin Gordon actually is he's the chief of the Open Records Division for the AG's office, and we'll recap in a minute. But let's
recap where we have just been. Grant Dorfman, who was hired in December 2020, takes us on a kind of a tour inside the AG's office in the late year of 2020 and early 2021. Essentially, Ashley, he describes sort of the workplace, the work volume of the work that was going on. And one of the things that he was overseeing was this internal investigation into the allegations by the whistleblowers and how he, redlined multiple drafts of that report. That he felt, committed to it because it was a report coming out of the office. And then actually he takes us through sort of his, the parts of the litigation that have his fingerprints on it after those 4 whistleblowers filed that lawsuit against the agency, and the litigation around the plea to the jurisdiction. And we saw Blake Brickman, one of the plaintiffs in that lawsuit, speak to this yesterday, where Brickman said that Paxton basically made this audacious claim that he that a suit could not be brought against him, basically. And so that was argued to a higher court, which ruled in favor of the whistleblowers. Then that was taken to the Texas Supreme Court, at which time earlier this year we know that Paxton and the whistleblowers entered into a negotiation that resulted in a tentative $3.3 million settlement. And that proposed settlement leads us to where we are right here, because lawmakers, particularly House members, said if we are going to be asked to fund this settlement, we need to understand how we got here, so we are going to investigate this thing far and wide. They did so, and they brought forward those articles of impeachment, which House members voted for in May, triggering this trial that we are having right now.
Yeah, Blake Brickman's testimony yesterday kind of led us to believe, and he set the terms that Paxton just tied up their lawsuit in court, as almost saying like this was just a tactic by him.
Right. I mean, yeah. The way he said it, he clearly implied a motivation by Ken Paxton.
Right. To kick it down the road. And so we're sort of hearing, and if you're someone who is watching this testimony, it's slow moving, certainly, as we are hearing about all of the legal workings of how these lawsuits work and what the motivation is and what they filed and when they filed it. And so then let's take a step back and talk about the testimony we heard just before Grant Dorfman took the stand, and that was from Henry De La Garza, and he's the HR director for the Office of Attorney General, and he really spoke to the firing of the whistleblowers. And so there are 4 whistleblowers who were fired, who were the subject of that lawsuit that Tony was telling us about, and they one of the things I thought, I actually want to pause and go back to Dorfman. One of the things I thought was interesting is they said 2 of them wanted their jobs back.
Right. Including David Maxwell.
David Maxwell, who is this famed, former
half a
Texas
century
Ranger.
Worked in law enforcement.
Yes, was the chief law enforcement, the law enforcement director for the AG's office. And this is a man in his 70s, and he wanted his job back. Not only him, but Ryan Vassar, who is a younger attorney. He is in his 30s, and he had, been promoted, if you will, to the position of Deputy Attorney General for Legal Counsel. So this is someone who is younger and growing in their career, and someone who, perhaps this was David Maxwell's, last assignment. We're not sure, but he certainly wasn't ready to leave, and they wanted their jobs back.
Well, and we know that David Maxwell also waged a fight for his, concerning, they call it, law enforcement calls it the F5 form, but basically it's a box that the employing law enforcement agency checks about whether or not your departure was honorable, dishonorable, or general.
Right, and his initially was just checked as general, and he wanted it to be noted that it was honorable. And
he fought for that.
He fought for that, and he won. And you can certainly see why someone who dedicated their life to law enforcement in Texas, why that would be, certainly such a big thing to them. But going back to Henry De La Garza, we were hearing about, what decisions were made and the thought process and the reports, because he also, De La Garza, is the ethics. He's the ethics coordinator. And so when attorneys within the office or people within the office have ethical questions, he is who they go to for answers. And he certainly said that, based on the information he was being given, that they needed to be fired, that
their terminations were supported by agency policy.
He talked about David Maxwell not moving an investigation forward, presumably the Nate Paul investigation.
Would not bring HR matters forward in an appropriate way. And De La Garza testified that he believed that his lack of engagement with HR on certain personnel matters possibly exposed the agency to litigation. So that was another one of the underpinnings for David Maxwell's termination, they said.
We heard him talk about one of the whistleblowers, and I believe this was Vassar who testified to this last week, that he was fired because they said he was being insubordinate. And so we heard De La Garza talking about what being insubordinate, what that is, what that looked like, that can include the tone and how you speak to your supervisor. And that was certainly what was written for him. But that overarching, they believed that given the resignation of the former top assistants, the right-hand men, if you will, for Paxton, that these 4 were not going to be able to work with Brent Webster in the way Brent Webster wanted to work with him. And I thought it was interesting that the prosecutions in the cross said, well, it sounds like he had a Webster problem, not a these 4 people problem.
Ashley, we're also almost about to forget to talk about something that I think is consequential, very consequential, that happened aside from the testimony, and that is yesterday there was this motion that was filed.
Rule 27 rule, yeah.
There was this motion that was filed yesterday that would have sought to consolidate the Senate's vote once this matter goes before them for a vote, and that is there was the discussion about whether or not, instead of taking 2 votes, the Senate would just take 1 vote, meaning 1 vote to convict or acquit Ken Paxton, and then number 2, if convicted, to permanently say that he can no longer be elected. So keep in mind, if he is convicted, he is automatically removed from office. But again, the second prong would have stopped him from seeking elected office in the state of Texas at any point in the future. So there was this motion that was filed. Ashley and I think before we went to lunch, gosh, I'm really losing track of time. I think that was before we went to lunch. We're talking about whether or not they would consider that motion as a body this afternoon. I think we floated the idea that it might be
well, certainly. So when the motion
rescinded.
was filed yesterday, the rule, right, we did float that idea. The rule was that, it has to be laid out for 24 hours. And we talked about what the political implications of that
and just the
could
motivation
possibly be.
behind
Right,
it.
so
I mean, frankly, it seemed a little confusing to us.
Yeah, because you wonder certainly if I'm
what
a
the calculation
senator,
was.
Yeah, if I'm a senator who perhaps is inclined to vote to convict and have him removed from office. And remember, there's a world where once he is convicted and removed from office, he can then run for the exact same office again. And with the argument that the voters now clearly know about everything that happened, and if they still choose to elect me, then they can elect me. And so, there may be a world where there are Republicans who say, okay, yes, we did find him guilty of these things, but we don't think it rises to the level that he could never run again, particularly if it's on something like the termination of the whistleblowers, or if it's on an article like that opinion that he had written to stop foreclosure sales. Well, okay, you shouldn't have done that. You were wrong for doing that. This is your punishment, but we're not going to disqualify you from running again. And so, but the prosecution wanted to combine it. And I don't know how much time plays a factor in that, because what happens is if he is convicted, each side then gets 15 minutes to argue about whether or not he should be disqualified. So it is almost like, if that happens, then we have to have another,
minute and another vote.
A whole other vote. You have to have 15 more minutes so 30 minutes for each side, 30 minutes total to argue whether or not he should be disqualified from office. Arguments that you assume the prosecution is going to make in its closing arguments in its hour of closing, and then they would vote again. Presumably before, and the rules aren't necessarily clear on if they would go through all the articles and then vote on disqualification
for each article, whether it's just one big vote.
Right, but like if he is convicted of one, and this is how my understanding is how it will work. If he is convicted of one and removed from office, and then they would take the vote on disqualification.
We share the same understanding.
Yes,
just FYI.
yes, and so, and then, because again, if he's convicted on one of the articles and then disqualified, there is then no need for us to sit down unless the Senate wants to send a message. There is no need for us to go through each one of these 16, the 15 other articles.
So if they choose to convict him on any article, it is game, no matter what, even if they do choose, it's game over.
For sure.
So when that moment comes, and by the way, I don't think we're particularly far from it.
Particularly.
Well, I mean, I've said all along, I think this is going to happen late Friday, early Saturday, but what do I know? That's the kind of best prediction. It's an educated prediction based on what Dan Patrick said earlier in the week. But although I do want to say, he has not been that bold with regard. I mean, he's given updates with regard to the number of hours both sides have left, but he's not been as bold about predicting when this could actually go to the jury.
No, not besides when he earlier this week said, by his calculations, by the time that they had remaining, both sides will have exhausted their 24 hours. That's the 24 hours that they each get to present evidence and cross-examine witnesses by today. And so when
I think we're behind that. Clearly, we're a little behind.
Well,
that,
I guess it depends on how long he wants to go today.
Fair.
Because we went to 7 o'clock earlier this week. We went past 6:30 yesterday.
We started a little later a couple of times.
Sure. To lunch breaks, which initially were 45 minutes and then bumped up to an hour, were then reduced again a little bit. So
I don't think we ever finished telling you the story, though. So the motion to consolidate this afternoon, Dan Patrick, Lieutenant Governor, announced that that motion to consolidate those two things had been withdrawn.
Yeah. So then that was, so the prosecution just decided to withdraw it, and the Senate doesn't have to vote. It would have required a vote of the Senate. Anything that would change any of these rules would require a vote of the Senate. I think can I just say, I think it's interesting. We talk a lot about the verdict, and certainly worth noting, Ken Paxton is not required in the rules to be present for the vote. He was only required to physically be here to enter the plea. It didn't say that he had to enter the plea himself, and in fact he did not.
Yeah.
His attorney, Tony Busby, did, and almost got reprimanded at one point because he was supposed to, rather than just saying guilty, not guilty,
they accused him of making a speech.
Yes, that he was making, because he was saying these accusations are absolutely false, and my client, in a true Tony Busby showman way, did all that until Rusty Hardin finally objected.
I think we're just here for a plea. Yeah.
Stop all of this, and let's just get it. And Dan Patrick agreed. But after that was the last time we saw him. The Senate broke for lunch, and he did not return. And so it is anyone's guess, if you will, as to when he will be back, if he will be back in the chamber. But we know where he plans to be 2 weeks from now.
We do know where he plans
Maine.
to be 2 weeks from now in Maine. He has announced a sit-down with Tucker Carlson, former Fox News host who now has his own show on X, the site formerly known as Twitter, which again, Ashley, I just want to say, it is interesting that he is, well, I guess it's actually not that interesting that he's agreeing to sit down with Tucker Carlson. I mean, by and large, as working journalists, we can both tell you that Ken Paxton rarely grants interviews to Texas journalists. That's just not something that he historically has done or does.
I feel like rare is a bit of an understatement.
Yeah, I mean, it's highly unusual.
As Attorney General, I interviewed Greg Abbott when he was Attorney General, certainly, but I've not been afforded the opportunity.
Yeah.
Ken, if you're watching.
Yeah, and it's not because we haven't asked,
please,
by the way.
We're asking again now. If you somehow are watching, or a member of your staff is watching, we would love to sit down and have an interview with you. I know we're not Tucker Carlson's over here, but certainly welcome the opportunity to chat with you and to hear what you have to say. He says that he intends to talk about the past 2 weeks of politics in Texas, and it should be interesting! Exclamation point. So
I do think, though, the fact that he is going to Tucker Carlson, he is going to have this national platform, also continues to underscore the fact that this case clearly goes beyond Texas, not just in terms of the interest, but also the implications for the GOP and the GOP national here in Texas, the GOP, and also the GOP nationally. In other words, should Ken Paxton be acquitted, whether or not we will continue to see sort of an even more hardening of his conservative, ultra-conservative, far-right policies, whether or not he will continue to push that. And then I think, Ashley, more broadly, too, whether or not there will be political retribution that has been threatened, whether or not it will be carried out for Republicans who have been deemed Republican in name only, or more moderate Republicans, whether or not there will be political retribution, for example, to Speaker of the House Dade Phelan, who presided over the chamber as they drafted and brought forward these articles of impeachment.
There's been a push to get rid of Phelan in his home district. That has certainly been a push.
And we've seen other House members who voted in favor of the articles of impeachment, sanctions in their home district by their home county Republican Party, et cetera. So I think, frankly, no matter what, I was just texting with a friend out of state, and frankly, no matter what happens, guilty or acquitted, this is going to have very broad implications in politics in Texas for the long haul, I think.
Yeah, I think it certainly will. Now, look, the reality is 60 Republicans voted
We recounted.
We recounted, and I recounted, and you don't even want to know how about all the pieces of paper I have over here because I was recounting and recounting and counting again. But
and it was 60 of 83 voting Republicans in the House.
Of 80, yes. Well, we should note, we say that there was 85. There are 85 Republicans in the House.
Right. One was absent.
One was absent, and one was present, not voting.
And did not vote, correct.
But so they
60
had the one who was present not voting had the opportunity, but chose not to.
But 60 of 83 who voted.
Yes, sure. Voted to. Yes, voted
Okay.
to. Yes.
That's right. Yeah.
Yeah.
Okay.
Yeah, sorry. Okay. Yes. Yes. I paused there because. But yes, so it will be interesting to see because there is a political machine, if you will, pushing for to hold the Republicans who voted yes accountable. I don't know that we are going to see. Certainly, I don't know if we're going to see 60 Republicans voted out of office. I mean, that would just be.
Almost unfathomable,
Right.
But whether or not it doesn't mean they won't that the further right will not gather opponents for many of them and support those opponents. So
So it will all come down to really the primary. I'm actually looking at a list of there are, I believe now at this point, we're to nearly 8 members of the House who have said they are not seeking re-election. And I was just trying to see where those numbers fell in terms of how people voted but I'm not seeing a correlation, just so you guys know, between who are the Republicans who don't intend to run and how they voted on that. So
the bottom line is that however this goes, there are going to be wide-ranging implications for the Republican Party and whether or not
Sure.
An acquittal actually moves the party further to the right.
Right, will be worth seeing.
We'll be following that in the months
Or,
and possibly years to come.
Are folks going to think that voters are going to forget about this?
Well,
by
that's
March?
also a very good point because, remember that poll that came out a couple of weeks ago from the University of Texas showed that many Republicans don't even really know about this.
No,
Now, obviously, that was going into the impeachment. Now that we are the trial, now that we have had this trial, clearly that has generated far more new headlines and coverage. Whether or not that has moved the needle on the number of Republicans who know about this trial or have kept up.
It wasn't just that they didn't know or that they had no opinion.
They had no opinion.
They just had no
Exactly.
opinion about it. But I think we also have to remember that when we're looking at some of these polls, one of the things that I would say is really important to note and to look at and to focus on is who's being polled. And so it is, registered voters, but also we don't know the extent to which the Republicans who participated in the poll are primary voters.
Correct.
And I'm not saying anything about I think that Texas, if you follow me, you know that I follow the Texas Politics Project polls. I think they are highly
bipartisan group,
and viable,
clearly,
and they clearly prove to be, based off of what we see in terms of when elections happen compared to what the polls say. I mean, there are viable polls, but it's interesting to see whether it's going to resonate with Texans or if Texans sort of say that they agree with however the senators are going to vote.
But the primary voters, we can assume, are very much keeping up with this, or at least more informed than maybe the more everyday
or just
Republican
are being
communicated.
I would argue almost being communicated to more.
Yes, very good point.
By the you haven't really seen other mediums operating at the degree that the conservative Republicans are operating.
And that's why, post by Donald Trump on Truth Social, somebody wrote me and said, well, why are you giving that any oxygen? Well, the answer is it's very significant insofar as informing the mindset of the primary voters out there. They are listening to what Donald Trump says.
And regardless of how you feel about it, that is the former president of the United States of America weighing in on an impeachment trial of a statewide elected official. And so regardless of what your feelings are, there's a certain level of respect and, frankly, weight that presidents and former presidents carry with the American public. So.
And knowing that the primary voters of the state listen to people like Donald Trump. Donald Trump Jr. Tweeted yesterday as well. So as we look to the Senate gallery right now, you can see this break. Actually, like these breaks, that seem to keep happening. The call time has gone past a little bit, and we are still waiting for them to
We are. I actually pulled up the latest Texas Tribune poll looking at Ken Paxton's approval rating from April 2021 until August 2023. And I can tell you that there started to be a deep decline in his approval rating in April 2023 ahead of the impeachment
trial. Yeah.
And that after the impeachment trial, it has just continued to drop.
But that's interesting timing, too, because we know that by April 2023, news of the proposed settlement had been made public.
Absolutely.
It was prior
it was probably in February.
Yeah, it was February. This, April 2023, though, of course, would have been prior to the unveiling of the impeachment articles by the House.
And certainly interesting that between February, the announcement of that, and April, Paxton started to see a bit of an increase, a 4% increase in his approval rating. But, as of now, as of August, last month, his approval rating dipping to 27% with 46% of folks saying that they disapprove of the job that he's doing. So, certainly, and that includes disapproval. I do want to add that includes disapproval 57% of independents and 23% of Republicans. So that's the highest amount of Republicans to disapprove of the job he's doing.
And that matters because while the senators who are voting are constitutionally required to focus on the evidence that is being brought to bear, I mean, you can rest assured they're also keeping in touch with the politics on the ground in their district and how voters in their districts are viewing all of this information that is coming out, whether or not they're viewing it favorably, moderately, or harshly.
Well, and I think it's been clear even from the senators' own, posting and limited comments that they made, because we are in a gag order, people also reaching out to their offices to say how they want their senators to vote. And you have to remember, this is not like legislation. You cannot try to get your point across on what you think about an issue and how you think a bill, whether or not it should become law, through your lawmaker right now. They took an oath to be jurors and to be impartial jurors.
And they have released, many of them have released statements saying, appreciate your phone call, but I can't talk to you, a constituent,
happy to talk to you about anything else.
But not this.
So we'll see what to make of that. Lieutenant Governor Dan Patrick is back
on the bench.
On the floor. I'm noticing some staff run to the back because there are senators who are not on the floor. So there were a few staffers running to the back.
He's just gavelled in.
So we are trying to see. Yep, where are they?
Yep.
Where are the senators? They're not out there just yet.
Yeah, he really admonished them early on, though, that he meant it.
Yes, and telling them, even if I'm not back here, you have to be back here at the time, that I call. And so.
Oh, there they come, some of them trickling in.
If you know anything about the Senate, these are 31 people who move at their own pace.
Yes, they do. Yes, they do. So, about to reconvene here for what we assume will be continued testimony.
Yes, Grant Dorfman was on the stand. Anthony Oso questioning him for the defense, and so, certainly we have no reason to believe that won't continue to be the case. In fact, I believe they are getting the witness now. Obviously, he had to step outside of the court, and so you can see one of the sergeant-at-arms walking to the door to escort him back in. Here he comes now.
Just to remind everybody once more, he is the number two person in the AG's office, was actually hired after the whistleblowers went public in December 2020 is when he joined the agency.
We'll listen back in on the trial now.
We'll be sure I have that right.
Thank you, Judge. Mr. Dorfman, we were just talking about the effect that a plea to jurisdiction actually has on the discovery in the case. Now, I want to focus, Eric, if you wouldn't mind focusing on the next page, top paragraph, which is the bottom paragraph of Article, bottom paragraph of Article 8. I want to read that to you. Testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Now, throughout the course of the lawsuit that the whistleblowers filed, are you aware of whether specific facts or allegations became public? And could you turn your mic on, sir?
Better?
Okay, I'm going to re-ask that question.
Please.
Were you aware of whether the specific facts or allegations with regard to the whistleblower suit became public?
Yes.
Can you tell us about in which ways, if you know, they became public?
Well, we talked about that earlier before I came to interview at the office. There were news stories that contained allegations made by the whistleblowers. It was about that same time, maybe a little later, that the lawsuit was filed. That was a news story and a very detailed state court petition that's public record, public filing, covered in the press accounts. And then I think they amended that petition twice between the original filing and early February. So there was a first amended maybe in December, and then in February, just before the plea of the jurisdiction hearing and the temporary injunction hearing, they filed a second amended petition, which I think is the last one. But that's 63 pages, very detailed allegations.
And I'm going to stop you real quick just to clarify. When you say they filed and amended petitions, can you talk to us a little bit about, well, who filed those petitions?
The four plaintiffs through their lawyers.
So David Maxwell, Mark Penley, Ryan Vassar, and Blake Brickman?
Yes.
And did those petitions include specific facts that they were alleging
Yes.
Attorney General Paxton and the Office of Attorney General committed?
Yes.
Okay. And those pleadings were actually available to the public, correct?
Yes.
You can look them up online?
Yes.
So, Eric, if you don't mind going back one page to the bottom paragraph, bottom clause. Article 8 alleges that Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that allegation true?
No. Can I explain?
Please do.
The settlement agreement didn't stay the wrongful termination suit. It was on appeal, and our petition for review was pending with the Supreme Court of Texas. That court doesn't have to take any case it doesn't want to, so you have to convince it to take the case. We had made a case. Filed 2 briefs to do that.
I'm going to stop you because we're going to get there, and I want to break that down.
Sorry.
But with regard to conspicuously delaying the discovery of facts,
The settlement agreement didn't do that.
And weren't the facts available to the public at this point anyway?
More than we discussed. Obviously, the petitions I mentioned, but the Court of Appeals decision is 30 pages and has bullet point block paragraph recitals from the pleadings. So it was restated the most serious allegations that the complaints, the petitions made, were restated in the Court of Appeals decision, which also garnered news attention when it came out.
Right. And you had talked about, I think, opposing counsel actually held up a document that was the Third Court of Appeals decision against the Office of Attorney General in this case, correct?
I'm sorry, what was your question?
Essentially that the Third Court of Appeals ruled against the Office of Attorney General.
Correct.
So you filed what with the Supreme Court?
A petition for review, an appeal, notice of appeal of the Third Court's decision with a petition for review asking the Supreme Court to take the case.
Can you explain to us, I deal predominantly with criminal law. Can you explain to us kind of how the process works when you file a petition for review with the Supreme Court of Texas?
It's in the form of a brief, very much like what we would call a merits brief, but it's not. It is simply an argument for why this case is sufficiently important to be one of the 100 or 110 cases that the Supreme Court can take from the entire state and rule on. They only hear so many oral arguments or take so many cases. So you have to convince them this is worthy of their attention. We tried to do just that. Okay. Our opponents filed a brief between our initial and reply brief explaining to the court they should not. They should let the Third Court of Appeals case stand, in which case the case would have then gone back to the trial court.
Okay. And so the Third Court of Appeals ruling was actually up for appeal, right?
Yes.
Was that ultimately ruled on, that appeal?
Not to this day, no.
Okay. Can you talk to us, are there certain sessions or time periods where the Supreme Court tends to hear cases?
I think that's right. I would defer to people, bless you, who argue in front of the Supreme Court for a living, but yes.
Okay. Do you feel that, I guess at any time, the Supreme Court can pull your case out of a hat to hear it, right?
I think that's right. They usually confer as a body, I think in person, although maybe by remote sometimes too, especially during COVID.
Okay. Does that have an effect on your ability to negotiate or work out a settlement with another party? Or does it affect the other party's maybe goal or them wanting to settle?
I don't know what the what is in your sentence.
The potential for the Supreme Court to pull your issue out of a hat and have it come before them.
Absolutely. It's a significant moment in a case. If they take it, I think the conventional wisdom would be they're not taking the Third Court's case if they decide to take it to affirm it, because they could just do that by denying the petition for review, save themselves time.
So what does that mean to you in the event that they might decide to take your case for review?
It would have altered our assessment of the case and made it, we would have felt very good about our chances for winning the appeal and dismissing the case outright.
Would that give you the upper hand potentially in settlement negotiations?
So much so that it might make settlement impossible.
Okay. Do you think, if you know, that had any effect on this case coming to a settlement, or at least settlement discussions starting in this whistleblower lawsuit?
I think that's why settlement negotiations started.
Okay. About what time did settlement negotiations actually begin in this case?
I'm not sure whether it was the very end of December or the first week or so in January of 2021, but about somewhere in that time.
2021 or 2022?
Sorry, 2023.
2023.
December 2022 and January 2023, thank you.
And just to clarify for the senators, the petition for review probably sat with the Supreme Court for quite a while, did it not?
Yes, I think we filed our initial petition, initial brief in July of 2022.
Okay. Who reached out to who to discuss settling the whistleblower lawsuit?
They reached out to us, my recollection.
And when you say they, you mean the whistleblower's attorneys?
Yes.
Okay. And can you talk to us about when, if you know, when that occurred?
Like same time, late December, early January of 2023.
And what did you do in response to them reaching out?
We discussed internally whether we wanted to, as they were requesting, go to mediation with a professional mediator in the Austin area.
What kinds of things were you discussing within your office as to why or why not settle a case?
We certainly wanted to discuss the pending petition for review and when it might be ruled on and what that might do to the party's willingness to mediate at that point if it happened. Whether we could get a professional mediator worth his or her salt on that short a notice, because I think the plaintiffs wanted to mediate in the next 7 to 10 days, maybe 14 at the outset, at the latest. because they were concerned that the Supreme Court might rule, and either way it ruled, the other side would feel good and the other side would feel bad and maybe couldn't. So risk creates settlement potential. So that would take out some of the risk.
Risk for the plaintiffs, right?
Risk to the plaintiffs that the court would grant it, and that might indicate their case was going to be dismissed maybe in a year, maybe in 9 months. They may have assessed it differently. That's how I would have seen it. And risk for us that if the court declined to accept our petition for review, the third court ruling stands, and we're back in trial court, and we have years perhaps of lawsuits and appeals, litigation and appeals, and the accompanying expense and time.
Who found the mediators?
The plaintiff's lawyers did that. I remember clearly because I was very skeptical that on that short a notice we would get any good mediators, and they told us in response to that, I think, that not only they had 2 or 3 who had available dates in the next week or two, which indicated to me, I told people at the office, that's a good sign that they're eager to mediate, because they must have called 10 or 12 people if they could find 2 or 3 available on that short a notice.
Okay, so it appeared to you that they intended to reach a settlement with you.
I think they were highly motivated to settle.
Okay, and that's based on your years of commercial litigation experience, I assume?
And as a mediator and trying to get a mediator on short notice.
Fair enough.
In fact, that was kind of my specialty, is I didn't mediate full time, so if parties couldn't get one of the regular mediators, they knew I was probably available.
Now, I want to zoom out a little bit, just generally speaking, in your years of experience as both a mediator, a judge, and a litigator. Does a party's willingness to settle a case indicate that maybe they think they're liable, or that they think that the other party is correct? Can you talk to me about that?
Sure. In my experience, especially mediating and representing parties who mediate their cases, both sides at least will say they like their case, and they frequently do. Mediation takes place when there's risk and uncertainty, and the only way to control the outcome is for the parties to reach an agreement and take it out of a jury's hands. You never know what a jury's going to do. You don't know who the jurors are. And it may be 2 years from now. It may be, again, 12 people pulled off the street. That's, if you want to subordinate your control of your affairs to those people, that's your choice, but that's expensive and risky.
Okay. And I'm
not sure I answered your question. Did I answer your question?
You answered my question. Okay. I appreciate it. And I want to bring actually your answer and apply it to the fact of this case. Did you have a conversation, without getting into specifics, with other OAG employees about settling, or at least going to a mediation with the plaintiffs in this case?
Oh, yes.
Okay. Now, when you entered those discussions, did you have a viewpoint on the strength of your case for the defense, the Office of Attorney General in this case?
Yes.
And what was your viewpoint?
Well, we hadn't probably looked at it in some time since filing the briefing, so we reconvened, revisited, reminded everybody where things were and what the arguments were, so we could assess that. I remember being a voice, as I am generally and maybe professionally. Look, let's go to mediation compared to years of trial and discovery and outside counsel on both sides. The expenses, the time is short. We can do it in a day, maybe 2. And the expenses, a rounding error in the budget, it's the responsible thing to do, especially in this case. It's one thing if you're a private plaintiff or defendant. It's another when you are dealing with the state's money. I think I felt and articulated that we kind of have a duty to explore settlement. Maybe it can't happen, but we should give it a try.
Right. Your Honor, at this time, may I approach the witness in the court and opposing counsel? Mr. Dorfman, I'm showing you what's been pre-marked as Attorney General Exhibit 335. Do you recognize this document?
Yes.
And what do you recognize this document to be?
This is an internal memo prepared by Chris Hilton, the chief of our General Litigation Division, assessing after we'd received settlement statements from, I think, 3 of the plaintiffs in the Whistleblower Act case, explaining why they thought their case was strong and what they thought they would recover at trial.
And let's not talk about the contents of the document, but could you tell me when this document was authored?
This, on its face, it says February 1st, 2023. I don't have any reason to doubt that's the date. That's the date, by the way, we mediated the case.
Okay.
So whether it was circulated before that date in draft form, I think it was, my recollection. We certainly discussed the contents of it internally before it was put into final form.
Okay, and did the findings, without getting into what the findings were or the subject matter of the document is, did this have an effect on your mindset going into the negotiations?
I don't know if it certainly informed me, and I relied upon it and had, I think it summarized the state of play well.
Okay, and is AG Exhibit 335, is that a fair and accurate copy of the memo that you received from Chris Hilton?
Give me 1 second.
Sure.
Yes.
Your Honor, at this time, I would offer AG Exhibit 335 into evidence.
Any
Mr. Ross,
objection?
I just want to make sure I have the right document. Is this the one with the AOG seal, but with Ken Paxton's name removed?
Yep, that's it.
Then no objection.
Admit
May I proceed?
335 AG exhibit into evidence. You may continue.
Thank you, Judge. Now, I don't want to go line by line in this report, but would you mind just summarizing the kind of what this document is and what you and Mr. Hilton's thought process was with regard to the financial aspect of this mediation in the case?
Sure. It's important to realize the mediation, we were told in no uncertain terms, Blake Brickman would not participate in mediation. He would not come to mediation. He would not be there. He was going to trial come hell or high water. So the opportunity was to settle with 3, not all 4 of the whistleblower plaintiffs. And this, so we received settlement statements from demands, basically. This is what we're going to present the week before, maybe a few days before the mediation date. And this was kind of a summary. I think collectively their attorneys argued for over $5 million in damages if they settled today. Of course, prejudgment interest and attorney's fees, as they said, would go up if the case continued, et cetera. But so for 3 of them, that was and we didn't want to take their word for it, so we asked one of our top attorneys to read those carefully, review the case law, and report back on what we would consider a more realistic assessment of the case's value was.
Okay. And just a brief question. This is just an inter-office memorandum, right?
Yes.
Objection leading.
Was this,
Overruled.
I'm going to ask the question again. Was this an inter-office memorandum?
Yes.
Did you send this out to anybody outside of the Attorney General's office?
No, we would not have done that.
Did you represent that you were the Attorney General or that you had the authority to act without Ken Paxton's, I don't know, authority in this document?
By this memo?
Yeah, by this
No.
memo. No, okay. So, can you tell us whether or not you felt that there was an ability to potentially save the state of Texas, the public of Texas, money by engaging in a mediation and potentially a settlement?
Well, I certainly thought that was the case. Otherwise, it wouldn't have been advisable to go to mediation.
Okay. Now, which specific plaintiffs in the whistleblower lawsuit were involved in the initial willingness to settle or request to settle the case?
Ryan Vassar, Mark Penley, and David Maxwell through their attorneys. I don't think we ever talked directly to them during this process.
What about Blake Brickman?
Well, as I said, Mr. Brickman's attorney told us, and actually the attorneys for the other 3 plaintiffs told us, Blake Brickman will not come to Austin. He will not participate in the mediation. He doesn't care. He wants his day in court.
Did you have a reason or idea as to why Mr. Brickman wanted his day in court?
Yeah, well, this is secondhand, so I understand Mr. Brickman is financially secure.
Objection, hearsay. This is secondhand.
Sustained.
Your Honor, I'd actually argue that it goes towards settlement agreements in this case, and under 408B, it should come into play.
Then my objection is 408. This goes to settlement, and it's also hearsay.
Which is if 408B is the exception to the rule, and
We've had this discussion on, I think, yesterday or the day before, so I sustain the objection.
Yes, Judge. Needless to say, Brickman's not there, is he?
Wasn't there, wasn't going to be there. Well, and I say wasn't there. We didn't anticipate this or plan this, but February 1st, the date we set for the mediation, ended up being the winter freeze.
Did Mr. Brickman's attorneys come to you with additional demand? Well, we'll get there. Talk to us about how the mediation went. What day do you recall you started mediation?
I believe it was a Wednesday, February 1st. And we had planned to be in Austin in person at the mediator, Patrick Keel's, former judge, office. As it happened, when the freeze set in, I stayed in Houston, and we were all on a Zoom.
And Mr. Dorfman, it's been a few years. Is it possible that the dates
might not have been a Wednesday?
Fair enough. Judge, may I approach Mr. Dorfman?
I think it was a Wednesday.
Was this a one-day mediation or a two-day mediation?
Ended up being initially planned to be one day, February 1st. We ended up, I think, on February 8th, having a second day by agreement with the plaintiff's attorneys.
Okay. Can you talk to us, and we'll get to the document in a second, but can you talk to us about how the first day of mediation went?
It went long. I think we broke sometime around midnight. I want to give Patrick Keel all the credit in the world. We didn't know until it started turning dark that he didn't have power in his house. And at some point, he was on his laptop and lost that power, couldn't recharge, so he's now on his phone on the Zoom call.
This is all happening online, right?
All happening online till midnight, and I think his juice gave out at some point.
Was it a good day of mediation, or was it a bad day of mediation?
I didn't have a whole lot of expectations that this would settle. It didn't, obviously, on that first day, but we got real close. And again, we came in with the expectation that the option today is to settle with 3 plaintiffs. Sometime between 5 and 6 p.m., Mr. Brickman showed up, again, remotely, so I don't know if he was physically present.
Sure. I'm going to stop you real quick. Was this the first day that it got real close and Mr. Brickman showed up, or the second day of mediation?
First day.
All right. So you guys are making headway. You said Mr. Brickman showed up. Can you talk to us about any effect that only 3 of the 4 plaintiffs were present that it had on you? And then what happens when Mr. Brickman shows up?
Well, I think Mr. Hilton's memo, Exhibit 335, speaks of the fact that it's more valuable to us to settle the entire case.
Okay. And why is that?
Because if we're settling with 3 of them, we're paying money out. Mm-hmm. Yet we still have to pay our lawyers and outside counsel on top of that to go to trial, to go to discovery, all the expense, maybe less time, maybe less discovery because it's just 1 plaintiff, but still time, resources that we would like to save, ideally by getting rid of the whole case at once.
Because what is the point of settling this case to you guys?
We have to be good stewards of the taxpayers' money, of the state fisc, and so we viewed this as any other case. One, that's why I argued for mediation, is we should at least try, if it's cheap and inexpensive to try and settle this and save that money and time and resources. And then settling with 3, I think it would be less valuable, but by the same token, we would offer less money. And I think Mr. Hilton says it in the reverse way in his memo that if Mr. Brickman would come to the table and we could make sure we don't have to expend any money after a settlement, I think his word is that would be worth a premium.
Okay. Talk to us about what happens when Brickman joins the negotiation table. How did that go down? Did you all reach out to Mr. Brickman, or did somebody else reach out to Mr. Brickman? What is your understanding?
I don't recall real clearly. I think it was a surprise to us.
And how did you take that surprise?
Good and bad.
Can you tell us about that?
The good is, look, we've all along preferred to settle with all four rather than piecemeal. It's more valuable, it's worth the premium for the reasons Mr. Hilton stated in the memo, the exhibit. So that was good. Bad is, wait a second, you told us all along, all week, maybe 2 weeks now, Blake Brickman's not interested in settlement, Blake Brickman's not going to participate in the mediation, he's not available, he's going to trial. And now that we're talking real dollars and it looks good that we might actually settle, now he's interested. All that, was that posturing? Were we being sold a bill of goods? That the suspicion crossed my mind.
Did you all reach a settlement that night?
No, we got real close, but no.
Now, I want to talk to you about AG Exhibit 423. Do you recognize this document?
Mr. Asa, be sure you speak up and stay on that mic a little bit.
Yes, Judge. Do you recognize AG Exhibit 423?
Yes, I do.
What do you recognize that document to be?
This is General Paxton conferring on me
Objection,
and
Your
on...
Honor. Testifying from a document, not in evidence.
I'm going to lay the predicate right now, Judge, and I'll instruct the witness.
Overruled.
Without getting into the contents of the document, what do you recognize this document to be?
It's a memo from Attorney General Paxton to me and to Chris Hilton, subject line settlement authority dated February 8.
Okay. And did this email have an effect on your abilities and your thought process when going into the mediation on day 2?
It confirmed what we had discussed internally, yes.
Okay. Did it grant you any form of authority?
Yes.
All right. Is this email that you see in AG 423 a fair and accurate copy of the email that you received from Ken Paxton on February 8th of 2023?
Yes.
At this time, Judge, I would offer AG Exhibit 423 into evidence.
Any objection?
Yes, Your Honor, I have 3 objections. First, it was never produced. Second, it was listed on their privilege log, so it was never produced. And 3, it's hearsay, so it is inadmissible.
I can address the objections. I didn't hear your second objection. Could you repeat that?
Yes, this document was identified on your privilege log, so you never gave it to us. And now you're bringing it to court for the first time and showing it to us for the first time.
Let me address the privilege log first. As an attorney for Ken Paxton, I think at this time we'd be willing to waive any privilege.
I appreciate that, but the fact
I'm not done, and if I could just finish my response, then I'd be happy to be quiet and let opposing counsel go. So first and foremost, as Ken Paxton's attorney, I'll waive the privilege. With regard to hearsay, it's not offered for the truth of the matter asserted. It goes towards the effect on the listener in the mediation the next day. We heard Mr. Dorfman just state that on the record. And his first objection with regard to it being not being on the witness list, or excuse me, the exhibit list, Judge, this is a rebuttal case at this point, and arguably we don't even have to put a case on. Most of our exhibits are rebuttal exhibits, but we did give them a list. I am arguing that this is a rebuttal exhibit, and for that reason,
Your Honor, may I respond?
Yes, you may.
Just so we're clear, the process that occurred was they produced a privilege log, never gave us this document, and now for the first time they're sandbagging us with this document without giving it to us. As the court is aware, you have ruled several times that documents that we did not produce would not come into evidence. They never gave this document to us. This is the first time we're ever seeing it. If they want to take every document off their privilege log and put it into the record, we're good with it. Otherwise, we have a valid objection. Second, Your Honor, it is clear hearsay. There is no business record. The predicate laid was not the standard for hearsay, and so it is inadmissible on all of those grounds.
if I, and just brief, yes, Judge. Well, I'm not aware of a privilege log that we came up with or provided to the House Board of Managers first and foremost. This list, I think the court is aware that the managers have just course of this trial and the Attorney General during the middle of trial. So to say that I'm sandbagging them is just simply not an accurate reflection of what's going on throughout this case. or with regard to this exhibit?
Okay. I've heard both arguments. Give us a moment. Jurors, please take your seat. After consultation with my team here, we will sustain the objection on hearsay. Continue.
Yes, Your Honor. Did General Paxton delegate you the authority to engage in a settlement agreement with the whistleblowers?
Yes.
Okay. Did he do so on February 8th of 2023?
On or about that date.
Where was Ken Paxton while the settlement agreement was going on?
I don't recall. I know he wasn't in Austin, and I believe he was traveling, which is in part why we needed to formalize my authority and the scope in case we weren't able to reach him on short notice if it appeared that we had an agreement subject, again, to his confirmation.
But to be clear, you guys formalized that delegation of duty, right?
Yes.
Right. So then you go into the second day of mediation, right?
Yes.
Will you talk to us about the second day of mediation?
I believe it was also remote by Zoom, even though the weather had cleared up. And I can't remember exactly when it was we agreed we had a deal, but the same dynamic had played out. Mr. Brickman was participating from the start on the second day at least, and so we were now dealing with 4 plaintiffs rather than a settlement for 3, as we had most of the first day of mediation.
And did you all reach a settlement agreement?
We did.
What was the settlement agreement that you all came to?
And to be certain, I think we reached it that day. It may have been the next morning.
Okay.
Before it was finalized.
Fair enough. What was the settlement agreement?
It was in the form of a mediated settlement agreement, payment of $3.3 million to the 4 plaintiffs in exchange for full and complete releases of liability against the Office of the Attorney General. There was other components we had agreed to, and if you have the copy of it, that might help me, but we had agreed to attempt with ERS to reinstate Mr. Vassar in his retirement plan. I think that was the only fringe benefit that was addressed, but I recall that. And then Mr. Maxwell had a separate F5 administrative hearing case in SOA, State Office of Administrative Hearings, which was abated pending the pendency of the whistleblower case. So that stayed, their filing stayed that proceeding, which was an attempt to reclassify him from a plain discharge to an honorable discharge, without which his employment according to them, as a law enforcement officer in Texas was problematic.
Okay. How did you feel about this agreement on behalf of the Office of Attorney General and the public of Texas?
I felt overall, especially now that it was a settlement of all 4 plaintiffs and the case would not go forward, it was a good assessment of our risk. To be honest, it's more than we would have liked to have settled for. I'm sure it's certainly was less than the plaintiffs' lawyers were telling us they should settle for. So that's probably, again, 95% of mediation settlements fall into that category.
Okay. Now, after this case comes to an agreement, you still have this petition for review in the Supreme Court, right?
It's still pending, yes.
And did you all file any motions with the plaintiff's attorneys in regard to that petition for review?
I think the next day.
Can you tell us what motion you filed with the plaintiff's attorneys in regard to that petition for review?
I believe it was styled as a joint motion to abate in the Supreme Court.
Can you tell us what the joint motion to abate did in this case?
Very short motion. It was simply telling the court, look, we've reached a settlement agreement that's binding and disposes of the case. If the Supreme Court went ahead and conferred and spent time deciding whether to take our case or not and made a decision, they'd be very peeved if they found out later that was wasted energy on their part. So we didn't want to upset the court. So we let them know, hey, we've reached a settlement. We're going to paper it up and finalize a larger document. It's all the bells and whistles, dot some I's, cross some T's, but you don't need to do anything now, and the parties are jointly asking you to put it aside for now.
Okay. Now, I want you to focus your attention on the article of impeachment that is on the screen right now. And it states, the settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that true?
No.
Why is that not true?
Well, the plea of the jurisdiction stayed the termination suit pending the Supreme Court, at that point, the Supreme Court's consideration. It didn't, whether it's conspicuous or not, it didn't delay the discovery of facts by settling. There was no discovery ongoing at that time. And the way this is written, it's sort of passive voice. But who's doing the delaying? Is the suggestion here that the whistleblowers, by filing a motion to abate with the Supreme Court, are trying to delay the discovery of facts?
Mr. Dorfman, I don't know. I didn't draft the articles of impeachment. Okay, so I want to move on to who pays this lawsuit. Who pays this lawsuit? Who pays the settlement?
Well, the defendant is the Office of the Attorney General. That's the party that would be liable and would pay any settlement obviously the legislature has to fund that. So those
And why is that? Why does the legislature have to fund that settlement?
goes back to our discussion about sovereign immunity. You can't sue the state without its consent, and even if you have a waiver of sovereign immunity, like the Texas Tort Claims Act or the Whistleblower Act, and you go get a judgment from a court, jury, verdict, all the way, hold it up to appeal, you have a final, unappealable judgment that entitles you to, let's say, $2 million against any state entity. This legislature, this body, can still decline to pay it. They have to agree.
Okay. And are you aware of whether that lawsuit has been paid?
No, it has not been paid, not been funded.
Now, did you engage, without getting into specific conversations of what was said, did you engage in discussions with the plaintiff's attorneys about getting the legislature to pay for this lawsuit?
Yes.
Were they for or against that?
For it. For it.
Now, were you a part of any specific discussions with any legislators about getting this lawsuit funded?
Yes, I was.
Okay. Can you talk to us, without getting into the specific conversations you had, can you talk to us about who it was that you met with to talk about the settlement?
I think there were 2 separate meetings that I participated in. Other people in our office had more, both on the House side and the Senate side. I recall a meeting with Senator Hughes where we discussed it, and with Senator Huffman.
And so you also mentioned that other people were meeting, or were other people meeting with other legislators about getting the settlement paid?
I believe
And obviously, as I mentioned earlier, we're having a little bit of technical difficulties, largely due to weather that is moving through the area. Our feed, I'm looking just at a screen here, is a little choppy. I'm not sure the audio, nope, it is down again. So we've been listening to testimony from Grant Dorfman, who was intimately involved, in fact, led the settlement discussion between Ken Paxton's Attorney General's office and 4 of those whistleblowers. He described this mediation that was going on in February earlier this year, and this tentative $3.3 million settlement. It does look like our feed is back up and the audio is coming through, so I'm going to go back there and let's listen to
and you still believe that
testimony.
That it is the state of Texas, the public funds, that should fund this settlement agreement, right?
I believe that initially. I believe it now if the case goes back to trial, which I think it's settled, but others may feel differently. All the reasons that were there before, again, we'll go back to the Supreme Court presumably, so, but the risk return of time, the certainty of time, litigation, resources, lawyers being devoted to this when they could be doing Biden administration lawsuits or something.
Let me stop you real quick. And just to be clear, you said if the case went back to trial, if the case had gone to trial and there was a judgment entered against the Office of Attorney General, should that still be paid from public funds?
That would be up to the legislature to decide.
Okay.
No one can make them.
Would Ken Paxton ever be personally liable for that lawsuit?
No, he's not a defendant.
Okay. You were at the Office of Attorney General. You're currently still working there, right?
Yes.
My understanding is you took leave for a little bit of time.
Yes.
Okay. About how long were you gone from the office?
From roughly early May. I returned to work remotely probably around the July 4th holiday.
So just recently, right?
Just recently.
Okay. I want to talk to you about the time period from when you started at the Office of Attorney General in December of 2020 up until you took leave in May of 2023, okay?
Okay.
Can you talk to us about some of the accomplishments made by the Attorney General's office under the leadership of Ken Paxton while you were there?
Well, I've referenced the Google ad tech lawsuit, one of the biggest antitrust cases, not just in the country, but in decades. That's still ongoing.
Objection. I apologize for interrupting. Anything after this lawsuit is irrelevant.
Actually, Judge, if I may be heard on the matter. Yesterday, the House Board of Managers elicited testimony from Blake Brickman. I have the transcript here and be happy to show the court, but they've opened the door to the Office of Attorney General's productivity after this whistleblower lawsuit, after these terminations occurred. They talked about the fact that there was not productivity and that the office wasn't functioning well. As a result, they've opened the door. That would leave a misimpression on the jury, and as a result, Mr. Dorfman should be able to talk about how the office is functioning.
Overruled.
So you talked to us about one of the lawsuits. Would you please continue to talk about the other accomplishments and the functioning of the Office of Attorney General?
I should have started with our immigration cases, which I'm probably most proud of.
Would you please tell us about your immigration cases?
Day one, I mentioned this maybe earlier, of the Biden administration, all the executive orders that came out. One was the 100-day moratorium. We were the first that no, if you have a deportable alien, they must be deported within 90 days, no exceptions. And that we continue to file and challenge and try to hold the Biden administration to the letter of the law and the rule of law on our border. Title 42 is one of those cases. DACA is a continuation of a case then Attorney General Abbott brought years ago against the Obama administration. We just won, I think, in the last week, a ruling out of the federal court in Houston that the revised Biden administration DACA policy is just as illegal, unlawful, I should say, as that in our favor.
Okay. I'm going to bring. You talked about big tech already. You talked about the Google case.
That's one of the Google cases. Another Google case we settled before I took leave. We broke away from a multi-state, all the states suing in one location. We broke out of that, filed our own lawsuit in Texas state court. We settled with Google for $8 million when all the other states put together settled for $9 million over the Google Pixel phones, and that was to the relief of Texas consumers who were deceived by misleading advertisements.
Any litigation with regard to opioids?
This is mostly before my time. The money has come in since I've been at the agency, but I can't claim credit. General Paxton himself led the nationwide negotiations on that, worked very hard on that, deserves the credit for that. And it's been billions in money from those manufacturers, distributors, marketers, consultants, pharmacies that were responsible for the opioid crisis that was so devastating.
And so based on what you've seen at the office during your time there, have they been successful in their efforts and their litigation under the leadership of Attorney General Ken Paxton?
I think so. I've been amazed at what we've accomplished. We've worked our lawyers very hard, and they've done very well. They deserve the credit. They're the ones going to court, making the winning arguments and filing the winning briefs, not me. So I don't want to seem like I'm tooting my own horn when I say CNN, no great fan of Attorney General Paxton or our office, had to concede in a news article that Texas had become the legal graveyard for Biden administration policies and executive orders.
Well, thank you, Mr. Dorfman. I'll pass the witness, Your Honor.
Your witness? That sound you're hearing you have not heard for a long time. It's called rain.
We're sure. All right. Hi, Mr. Dorfman. How are you?
I'm very good, thank you.
I was.
The mic's not on, Mr.
Can you hear me?
Yes, sir.
Mr. Dorfman, we were looking at Exhibit 335 that was introduced by your counsel, or counsel for Mr. Paxton. Can you pull that up for me, Stacy? No.
Check your mic one more time. It doesn't sound right.
Is it not working?
No, it is now, but you're tall enough that you're going to have to bend down a little bit.
Yes, Mr. President. Is this the memo that you were talking about on 335 with the counsel a moment ago?
It's one of them, yes.
And this memo was created by Chris Hilton?
I believe so, yes.
And one of the lawyers standing over there, sitting over there?
Sitting, yes.
Sitting, yes. When you got this memo, were you shocked?
By what?
by the fact that Mr. Hilton was attempting to usurp the power of Ken Paxton by removing his name from the letterhead?
No.
Did it appall you?
No.
Was it simply a matter of Mr. Hilton picking out this letterhead that is available to every employee of the AG's office?
I think you'd have to ask Mr. Hilton about that. I don't know.
You talked about the internal investigation that was conducted by the Attorney General's office, correct?
Yes.
And you talked about the fact that it needed to be fair.
Yes.
It needed to be unbiased.
Well, it needed to be objective, I think is the word I used.
And the subject of that investigation was Ken Paxton.
One of the subjects of that investigation.
It certainly was a big part of it, right?
The allegations against him were a big part of it.
Your Honor, may I approach the witness?
Thank you.
Mr. Dorfman, I am showing you what has been marked as 524, Exhibit 524. Do you recognize this document?
Give me 1 minute to read it quickly. Can you restate your question, please?
Yes, maybe I can make it easier. You see your email address right there, halfway down the page?
I do.
This is an email exchange that you received, you were on,
Yes.
and so as a result, you recognize this document.
Yes.
And, you know, to use a predicate that's being laid by your counsel, this fairly and accurately represents the email as well as the attachment.
I think that's right.
Your Honor, at this time, we offer Exhibit 524.
Any objection?
Yes, Judge, I'd object to hearsay, and they haven't provided a proper foundation for this witness to sponsor this document.
Your Honor, we have a business record affidavit that overcomes hearsay. That gets by that, and the predicate is this witness was part of this email exchange, is a proper sponsoring witness, testified it fairly and accurately represents the email exchange that he was a part of.
Judge, I'm just confused. I don't have a copy of a business record affidavit.
You do have a copy of the business record affidavit. I didn't hand it to you, but if you want, I can get it for you.
Well, that'd be great. I think part of the rule is that it's, got to be provided to counsel, so that would be good.
I will,
Would you provide him a copy?
yes.
Judge, if I could just have a moment to look at the business record affidavit.
Take a moment.
Thank you.
Your Honor, I assume we're stopping the clock, respectfully?
Judge, I mean, I don't see why it should. They're offering it.
If it's a minute, we're not stopping the clock, but if it's longer than that, I'll stop it.
Judge, I have to reurge my objection. This business record affidavit is not the correct affidavit for these documents. It references Office of Attorney General numbers that are just not contained on the documents that counsel has provided me. And so I can't verify that it's the document that he's purporting it to be.
And we don't have a copy either of the business affidavit.
I can get you a copy.
That would be good. Yeah, it's supposed to be attached so that we know.
I appreciate that, Your Honor. It was attached to a bigger swath of documents. This is just one of the documents that's part of it.
We will stop the clock and give you credit for a couple of minutes. We will stop the clock and give you credit for a couple of minutes here. Mr. Dutko, I will say I stopped the clock, but when either side has not been ready to present us what is needed, we have not stopped the clock previously. So I've given you 2 minutes here, but I don't know how long you're going to take.
Yes, Your Honor.
It does not seem you have your paperwork together.
Yes.
So can we continue and get the clock running and come back to that if you'd like?
Yes.
All right. Resume the clock, resume your questioning.
May I proceed? Mr. Dorfman, when you were on direct examination, you spent a lot of time talking about the fact that the quality of attorney that is currently at the Attorney General's office. You remember that?
Yeah, I think so.
And you said how you were proud to walk through the halls and the lawyers and the high caliber of lawyers.
I don't recall saying that. It's certainly true, but I don't recall saying it.
And you were talking about how good the lawyers are and how hard they work. Do you remember that?
Yes.
Yet, despite the fact that there's the high quality of lawyers that currently exists at the Attorney General's office, Ken Paxton had to hire Louis Brisboe as outside counsel.
Didn't have to, he did.
And it was certainly something that could have been handled internally.
I'm not going to agree with you on that. Now, I have an explanation why.
Okay. Are you aware of the fact that Louis Brisboe has billed the Texas taxpayers $524,000 for the work that was done?
Yes, I am.
And that doesn't bother you?
I think I've been very clear that I view the Texas fisc as a sacred calling for us. That's very important for us to preserve it and spend it wisely. Again, I had a reason why I supported the hiring of Louis Brisboe as outside counsel. But part of the motivation for settlement was to stop paying Louis Brisboe as outside counsel.
Your Honor, we have the business record affidavit that we were going to present to opposing counsel.
Okay.
Is this for this document? Yes. He's got extra copies of VRAs on. Again, Judge, I got to re-urge the objection. The document that they've handed me doesn't have a single Bates label on it, and this business record affidavit talks about Bates label documents. No way for me to verify the validity of these documents.
Your Honor, just so we're clear, these are documents that...
Could I have a copy of that?
Yes.
And before you answer his objection, let us look at this.
And again, this is continuing testimony, Ashley, that we have heard all afternoon from Grant Dorfman. At this particular moment, they are talking about the nature of the settlements that were reached with those 4 whistleblowers, and really speaking specifically to Article 8, which is labeled disregard of official duty. It says Paxton misused his official powers by concealing his wrongful acts in connection with the whistleblower's complaints. It says that this tentative agreement quote, conspicuously delayed the discovery of facts and testimony at trial to Paxton's advantage. And so what we are hearing now is the evolution of this settlement, how it came to be. That is what Mr. Dorfman is testifying to right now, and his intimate involvement. In fact, he formally represented Ken Paxton in the mediation settlement discussion.
The plea to the jurisdiction stays the case.
Once it's denied or granted.
Right. And so when you filed that plea to the jurisdiction, you, as the Attorney General's office, knew that the case would be stayed.
Yes.
That meant there would be no written discovery.
Yes.
That meant there would be no deposition discovery.
Right.
That means that Ken Paxton did not have to testify under oath for the entire time that that plea to the jurisdiction was being determined.
No one had to testify, yes.
Right, but Ken Paxton didn't as well, right?
Yes.
And so when you filed it, you knew that was going to happen.
Once a ruling was made, yes.
Right. And even though you lost at the trial court, instead of going back to the case and conducting discovery, you appealed it to the Court of Appeals.
Well, we didn't lose the case at the trial court. We lost the plea.
Right, you lost the plea to the jurisdiction.
We disagreed with that and we appealed it, yes.
Which means that when you lost that case, that plea to the jurisdiction, that meant if you did not appeal it, you could go back to the trial court and take discovery.
If we chose not to appeal it?
Right.
I suppose that's true.
And then you appealed it.
We did.
And lost.
We lost in the third court.
So then, instead of going back to the trial court to conduct discovery, where Mr. Paxton would have to give his deposition, you took a flyer and took it to the Supreme Court.
I disagree with you that we took a flyer. We urged the constitutional separation of powers, which is a pretty important constitutional doctrine, and we also relied on the sovereign immunity of the state, which this body thinks pretty importantly of as well.
Right, and then while the case was pending at the Supreme Court, there was an appeal, election, right?
Yes.
And after the election, before the Supreme Court, where you said you had a good faith basis to go, immediately after that's when you guys settled, right?
Not immediately, no.
Shortly thereafter.
We settled 3 months later, a little more than 3 months later.
Your Honor, I was told that the document that was printed for everybody had the Bates label that ran off the bottom, and so now I have a version that has the Bates label that identifies it as a document within the range on the Attorney General's, on the business record affidavit. Since it was a short notice, I have one copy. I would like to show it to opposing counsel and then bring it to the court, if that is okay.
Can I see it first?
Yes, Your Honor.
As we are continuing to listen to the testimony of Grant Dorfman, I really want to point out something, key that I think was said, Tony, is that he was asked, should the state have paid for this settlement that launched this entire impeachment, him deferring and saying, well, that's really a question for the legislature. But then the next question was, well, is Ken Paxton liable for, this? Should he have had to pay it? And his answer was no. that Ken Paxton is really not a defendant. This is a lawsuit against the state of Texas, the Office of the Attorney General.
And in the court of public opinion, at least, that has been one of the. Has he called a recess, by the way? It sure looks like it.
I don't think he called a recess. We're watching, certainly anytime, and he kind of noted this earlier, anytime, and this is why Tony asked this, anytime they're on a break or they're talking, you see the senators get up and move about.
But like seemingly more frequently, which I think may be an indication that, I was just about to say, which I think is an indication that, you know, the fatigue is setting in terms of this trial.
We've been going
8 days now.
8 days, and for, you know, countless hours each day, starting today, you know, shortly after 9. And so I do think that there begins to get, you know, the senators certainly like to move about. It's interesting you're seeing, you were not seeing it. Sorry, I'm seeing on another camera, Senator Royce West going to the timekeeper and asking them
for an update. He wants to know.
Update about how much time we have left.
So, Ashley, with regard to the cross-examination, though, that is happening of Mr. Dorfman, excuse me. This is also, again, really speaking directly to Article 8, dealing with the proposed settlement. And that is, it is alleged that Ken Paxton deprived voters of an opportunity to make an informed decision of the 2022 election for Attorney General. And so there is this discussion about whether or not Ken Paxton's discussion, there it is.
Well, that's not, we're talking about Article 8.
Article 8, whether or not Ken Paxton took steps to delay this lawsuit from going forward by challenging the jurisdiction. And so it did go to the Third Court of Appeals, which ruled in favor of the plaintiffs, the whistleblowers. Then Ken Paxton and his staff challenged it to the state Supreme Court. And so there was like a 2-year gap there before the plaintiffs and the Attorney General's office entered into a settlement negotiation in February 2021. Ashley, what happened in the meantime?
Well, a big old election happened in the meantime. You know, in 2022, Ken Paxton was reelected. And so I think that one of the things, though, Tony, is one of those filings halted everything. And that was one of the things that we heard Dorfman talk about earlier was once, you know, one of the filings challenging it was filed, it stopped discovery.
It stopped discovery,
it stopped everything.
So the plaintiffs then could not get information to not only build their case, but according to the House impeachment managers, there was an active effort by Ken Paxton to conceal that information.
Right, and so it looks like they're starting back up now.
A second to settle down here for a moment.
Let's listen in.
You may continue.
Mr. Dorfman, I'm going to make this short because everyone's ready to be done. You started in December of 2020.
That's a yes.
And when you started, all of the whistleblowers had already been fired or resigned, correct?
Yes.
You didn't interview Mr. Vassar?
No, I did not.
You didn't interview Mr. Bangert?
No.
You didn't determine the veracity of what their testimony is in front of this Senate?
I haven't been allowed to watch their testimony, so I don't know.
Right, but you didn't determine the truthfulness of what they were saying?
To the Senate?
No, as far as the whistleblowing allegations.
We took their pleadings at face value and addressed those in the report.
I appreciate that, but you didn't make a determination yourself.
I never interviewed them, but the report is I don't know if you call it a determination, it's a report of our office.
Right, but when it comes to determining personal knowledge about the allegations that are made here in the Senate, the allegations that are made before you got there, your testimony would not be helpful as far as personal knowledge goes.
I have no personal knowledge of what happened. I didn't hear any conversations in September or October or prior to that at the agency. That's true.
Pass the witness, Your Honor.
No redirect, Your Honor. Can we excuse the witness, both sides?
Yes,
Good?
Judge.
Thank you, Judge. Mr. Busby, who is the next witness?
Your Honor, Attorney General Ken Paxton, res.
Well,
And
there
that's
you have it.
breaking news. Yeah.
That the Attorney General, the defense rests its case. And so you are now seeing Lieutenant Governor Dan Patrick confer with the attorneys there. We know that each side, per the rules, is going to be given an hour each to present rebuttal evidence, and that is set to happen before their hour each for closing arguments. You know, and to Dan Patrick's credit, he said they would be out of time today.
He did say that.
And here we are.
Although, I think they may have still had a little bit of time on the clock. They are choosing to, the defense is choosing to rest. Yeah.
Yes, certainly both sides have some time on the clock because there was no announcement that the clock had run out for them. So, certainly a new
Well, you know, this happened
development.
yesterday, Ashley, at like 5:30. We had these major situation unfold, although that ultimately was resolved. But now, if we look on the Senate floor, you know, everyone is trying to figure out what happens next, if they are going to possibly proceed with rebuttal evidence tonight, or, I mean, Ashley, even get to closing arguments. I think it may be possible that they do closing arguments first thing in the morning, tomorrow morning.
I think that's much more likely than
give everybody a chance to sleep tonight and get ready. And then comes the deliberation. But I think as we sit here now, knowing that the defense has rested its case and there are only, you know, a few hours left on the clock, judging as we sit here now, it seems very possible that this could come to some sort of decision as early as tomorrow.
Yeah, they're talking now. I think certainly, you know, the time is going to play a factor in all of this. And if they wish to present their rebuttal evidence now, but also if they need time to prepare.
That's right.
That rebuttal
Very good
evidence,
point.
that hour, you know, that could happen tomorrow. So then we're looking at 2 hours and a lunch break and 2 more hours for closings. And then that's really pushing, you know, when it gets into the hands of the jury. But certainly, Dan Patrick has said that once this is in the hands of the senators, there is no stopping. There are no off days. They will deliberate until they have a decision. And so I will tell you, when Tony Busby stood up, and I gasped for a moment, Tony.
I know, I know. Well, yesterday he did kind of take us by, well, he didn't kind of, he took me by surprise.
Right, because the question to him was, you know, Dan Patrick said, defense, you can call your next witness. And Tony Busby said, Attorney General Ken Paxton. And then he almost paused and then said, rest, you know, our case. And so for a moment I thought, well, is he calling Paxton?
I wondered that too. I wondered that too.
But certainly that was not the case. And so with both sides resting, and we are done with calling witnesses and cross-examining witnesses, that portion of this trial, the presentation of the evidence, is complete now. And it leaves you to wonder about, in my mind, one article in particular. It's Article 9, and we heard no testimony. And this is the article related to whether or not Laura Olson received a job from Nate Paul to benefit Paxton, to sort of say thank you to Paxton for all of the help that he was giving Paul. And so we heard absolutely no testimony on that.
Well, and the reason is that when they call Laura Olson, the woman to be employed, or who was employed, yes, she was at the Capitol. Yes, we saw pictures of her. Yes, we saw video of her. We also saw pictures and video of her leaving the Capitol around 5 o'clock yesterday afternoon after the lieutenant governor made the announcement that she was present but deemed unavailable to testify. And what we have subsequently learned through our own reporting is that she had planned to plead the Fifth and not offer any real testimony there.
And certainly you have to wonder then what happens in this rebuttal evidence to try to shore up that very open ended issue within the prosecution's case.
Exactly. And so again, it sure seems possible that this trial could reach some sort of conclusion tomorrow night, potentially late tomorrow night, during the day tomorrow. It's unknown at this point.
I want to say, interestingly, we were taking a look at State Senator Roland Gutierrez just a moment ago.
Oh, yes, you noted that.
And Gutierrez is running for U.S. Senate. He wants to challenge Ted Cruz, and he is set to be at an event in Corpus Christi tomorrow night, Saturday night, excuse me. Today is Thursday. Saturday night at 7 p.m. And is seemingly still planning from emails that we received, still planning to be there. So.
And look, Ashley, I mean, let's just be honest. These senators are human. They have been listening to days and days of testimony. Certainly not that this would be any guiding force. But big football game on Saturday. Several big football games on Saturday. There is certainly a desire, I think it's safe to say, by the senators to get this over with.
Yeah, and at the same time, we do want to point out these are lawmakers who they have had to work on weekends before. They have had to miss key moments in their personal lives before because of the call of duty. And certainly we are not suggesting that they would not fulfill their duty just so that they could enjoy a weekend at home. But also, I think there's an inclination of where parties stand. Now, what I think is interesting right now is that not only are the parties at the dais, but so are a group of senators. And this has not been allowed.
Yeah.
It's been very clear that in fact, Dan Patrick told them they aren't allowed at the desk during these proceedings. But that leads me to think perhaps they're talking about scheduling, perhaps they're talking about the processes rather than, and you can see it's several of the senators standing right there listening in. Including Chairman Brian Birdwell, who really wrote the rules.
Yes.
The Senate certainly debated those rules over the course of 2 days before voting to approve them. But, they're all listening in. I think they too want to know what's
next. Yeah.
And we started the day this morning. When we started the day, the prosecution had 2.5 hours left. The defense had about 8.5 hours left. And we have, it is now 5:40 and we've been listening to testimony all day. So but they clearly did have time left.
Yes, they clearly had time left, but again chose to rest their case. So also when you think about it too, Ashley, I think it's noteworthy that the state took, the majority of this trial time to present its case. My days are kind of blurring together, but the defense only used a fraction of that time, calling its first witness yesterday. Yeah. I said it's running together.
So I think while it's interesting, it's certainly worth pointing out. The Dan Patrick now shooing the senators away, telling them that they cannot be standing at the desk while these things are being heard and discussed. So the senators who were standing there got pushed away. But certainly while they were each given 24 hours, and the defense calling all of its witnesses in one day, the defense really did push back a lot and spent a lot of time in cross-examination.
And I think in many ways felt as though they made their case by poking holes in the prosecution.
So much so that they got to the point where they, yesterday, kind of this big moment after the prosecution rested, was they filed a motion for a directed verdict, meaning there wasn't enough evidence to prove the case. It should all be thrown out.
Now, Ashley, we've seen this before. Some of these senators look like, I don't think we know at this point, but some of the senators do look like they're kind of packing up a little bit.
Certainly Senator Donna Campbell grabbing a bag as she walks out, but she also could be taking her bag
exactly
somewhere else. Let's talk a little bit about, because it is certainly noteworthy, the defense calling for witnesses today and being done in one day. So they initially actually wanted to call a law professor by the name of Michael Gerhardt. They called him yesterday at 6:30. It was after 6:30.
Oh, are we going to get it?
Oh, they're walking to their seats. Now, yesterday they adjourned without telling us anything. Now we have Senator Brian Birdwell, who again is the chair of the Rules Committee for this trial. He is on the dais at the last camera view that we had. We could see him on the dais talking. He and Senator Whitmire, you can see them there on the left. They're walking down the stairs. And Dan Patrick continuing to confer with his legal counsel. Because Dan Patrick is not himself an attorney or a judge, he is permitted to have, in the rules, he is permitted to have his own legal counsel. And so that judge sitting next to him, the woman directly next to him with the blonde hair, is Judge Lana Myers. And then he has 3 other members of his own legal counsel to help guide him as he makes decisions in this case. But when we talk about the defense, going back to my prior thought, they called a witness yesterday after 6:30, Michael Gerhardt, who is a law professor at UNC, and they wanted him to serve as an expert witness. We later learned this morning, they said, okay, never mind, we'll start fresh in the morning, but they didn't call him. And we learned as they were questioning the second witness, Mr. Hilton, Chris Hilton, who is helping with Paxton's defense, noted that the House prosecutors objected to his testimony, objecting to having him be, and so they withdrew him from the witness list. And so instead we heard from 4 current employees of the Attorney General's office.
And now Dan Patrick here we go.
You can still stand. I just need a little quiet. Both parties come back.
Okay, so, Dan Patrick actually just telling the senators to quiet down a bit. We're not quite done. Let's finish talking about this some more. Hearing today, though, from 4 employees of the Texas Attorney General's office who really spoke to, and I want to note this, I think all of which, except for one of them, except for Henry De La Garza, who is the HR director, all of them being promoted to those positions after the whistleblowers left. So 3 of the 4.
In fact, Grant Dorfman, talked about the fact that he knew there were openings when he got the call from Brent Webster to possibly join the AG's office, that he was aware of what had gone on inside the agency with the whistleblowers and their allegations against Ken Paxton.
Well, it's certainly interesting to also hear one of the witnesses, and you have to forgive me, I can't remember if it was Austin Kinghorn, but I do believe it was him, who said he took the job knowing about what had happened, but promised his wife.
Talked to his wife
And promised her that if he felt like there was something going on, that he would resign himself. And that was certainly an interesting, because again, this was very public at this point.
But clearly the point of all of these witnesses was to, one by one, sort of undermine the strength of really every single one of these impeachment articles. There were some that they tackled more specifically than others. Again, just thinking back to the testimony earlier in the day, we saw Chris Hilton Again, Chris Hilton is an AG's office employee who took a leave of absence to defend Ken Paxton, taking his witness, not through every single impeachment article, but certainly multiple impeachment articles, going line by line. Did he do this? Did he order a sham investigation, for example? And
that's one of the things that I think is interesting is you have to remember that language is included in the impeachment article.
Yes.
Yeah, that Ken Paxton had his attorneys investigate a, quote, baseless claim and that he conducted a, quote, sham investigation. So those are things that
chip away.
Certainly, they didn't use broad language that could be a little more open to interpretation by the senators.
And we saw that yesterday with Brian Kammack, the special prosecutor. Did you believe, Mr. Kammack, that you were investigating a baseless claim?
And he said
no.
That he truly believed Nate Paul's claims. He believed them to be feasible, and certainly he thought that Ken Paxton thought that they were feasible, and that's why he was having him, do all of this. Let's talk about the articles and sort of the testimony that we heard today from members who were in Paxton's office. So, Article 1 deals with the protection of a charitable organization and whether or not the office intervened in a lawsuit between the nonprofit Midday Foundation and Nate Paul in order to benefit Paul. I think there's a lot of testimony about that, Tony, that we had previously heard. And Tony is actually getting ready to have to
I'm
leave
sorry.
me.
By the way, I've got to go do our 6 o'clock newscast. I will be back, though. Sorry, Ashley. My apologies in advance.
No, so much for that conversation that I was trying to have with you, friend, where we were going to go through this. I did too, and realizing hello, we're trying to also send notes. This is the joy of being live. So while I am talking to you, I'm trying to send notes to people. Tony's trying to get his mic off and go run to our other studio to do the 6. We didn't know we were about to be potted up for you but hello to you. Thank you for watching. You know what, since we're here, I'm going to go ahead and send this text message to my boss that we were in the middle as we are talking about this. But one of the things that I want to go back to certainly is Tony is headed out. Tony, we'll see you back here shortly after the 6 p.m. Is what we heard about when it came to the open records request. That was certainly the center of the testimony with Justin Gordon. Justin Gordon is the chief Open Records Division officer within the Texas Attorney General's office. And there are 2 articles directly related to the open records process. And the House managers allege that Ken Paxton misused his power to administer public information law by directing his employees to refuse to give a decision for a request for DPS records. Now, based on previous testimony, we know that Nate Paul wanted some information about the raids that had been executed on his properties. And those raids were conducted not only by members of the FBI, but in conjunction with and with assistance from DPS officers. And so DPS troopers. And so that they wanted that information. They were trying to find out specifically what it was that they were looking for, because Nate Paul believed that the warrant had been altered on the spot. He believed, according to testimony, that they initially raided his properties looking for guns and drugs, and that when they did not find those, about 2 hours into the search, they switched it to white-collar crimes and started looking for financial documents. We do know that Nate Paul has since been indicted by the federal government on some of those what you would call white-collar charges, saying that he either that he told investors a greater estimate or a lower estimate of, his worth and potential in investments so that he could have that and get them involved in business with him. But what we heard from Justin Gordon, who I want to note is one of the employees who was an employee with the AG's office at the time of this, he testified that DPS missed a critical deadline. So DPS challenged the request. And so if you've never submitted a public information request, if there's any type of information you want from a law enforcement agency or a city, a governmental entity, you can submit a request for that information. They have a certain amount of time that they have to produce that information to you, or after that time frame, they can tell you that they are going to request an opinion of the Attorney General because they do not wish to release that information. When they do that, that then triggers a process within the AG's office where the AG's office will have to decide whether they will side with the law enforcement agency to not release that information, or you, the public, or the requester, to give them that information, or sometimes they're somewhere in between. But more often than not, the stance of the Attorney General of the state of Texas office is to side with law enforcement and to deny the requester that information. This is something that we in the news business go through quite often. And Justin Gordon said DPS actually missed the 15-day deadline that they had to submit some information explaining why they did not want to release that information. And so Ken Paxton then told his employees not to take a side, not to deny the information, and to Gordon's testimony saying that because they didn't really know if DPS wanted it to be released, but they assumed that they did not necessarily have strong objections to the information being released because they did not respond within the 15-day time period that they had to respond. And so Ken Paxton then directs his employees to refuse to give a decision in that particular request. Now, we know based off of other testimony and information, Nate Paul and Nate Paul's attorneys did get information, including a redacted copy of a sealed federal document, but Justin Gordon testifying that he got that from the FBI themselves. But this really speaks to these claims from the House that sort of in the dark of night, Drew Wicker, Ken Paxton's executive aide, met up with Paul and handed him over, folders with documents with information, which we know that did happen, but just sort of the background on how that happened. And so Article 4 alleges that Paxton misused his official power to administer the public information law by improperly obtaining access to that non-public, that sealed federal document, and giving that information to Nate Paul for Nate Paul's benefit. We know that while the FBI provided a redacted version, that he apparently is accused of providing a different version of that document to Nate Paul. The whistleblowers also talked, not necessarily directly, but they spoke to Article 5, and they actually did call up Article 5 a few times. And this is disregard of official duty in the engagement of CAMIC is how it is worded. But Ken Paxton hired an outside attorney, a young attorney, with only 5 years of experience and no experience as a prosecutor to serve as a special prosecutor in the AG's office solely to investigate Nate Paul's claims and to create a report. And this is, Tony and I were talking about this earlier, this is where you see that language, baseless complaint. That is the language that is included in the actual impeachment article that was passed. And so that is where perhaps things get a little harder to decipher, because the article says, while holding office as Attorney General, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. They argued that Brandon Kamick was not an attorney pro tem, but a special prosecutor. And then also specifically, Paxton engaged Brandon Kamick, a licensed attorney, to conduct an investigation into a baseless complaint, during which Kamick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. And so we do know that Kamick was hired, and he testified that he was hired under oath to investigate Nate Paul's claims. But whether or not it was believed to be a baseless complaint is another issue. And you had question certainly throughout this, because Brandon Kamich worked for the Attorney General's office but never was paid for his work. They agree. He submitted what his fee statement was. He sent an invoice to the office, and we actually heard Austin Kinghorn, who spoke to us. He is now the Associate Deputy Attorney General for Legal Counsel, and he talked about how he received that invoice, but he did not have a contract on file with Brandon Kamich's name on it. But the question really was, kind of who hired Brandon Kamich and how long, was he employed with the AG's office? Well, we know from Kamich's testimony that he did have a copy of an employment contract, and that contract had Ken Paxton's signature on it himself. And one of the, another element of Article 5 is how Brandon Kamich was hired, and we heard the whistleblowers testify about the proper channels and the rules in which people are hired to work in the Attorney General's office, and the hiring of Brandon Kamich certainly went counter to that. And they said, the Attorney General himself does not sign employment contracts, and so to have an employment contract with his signature on it certainly seemed unusual. However, those same whistleblowers testified that Paxton told them he was the one who signed it. And it was later in that sort of Starbucks meeting where Kamich was fired that he was told that he did not have a contract. And in fact, later we went on to see when the Attorney General's office did its investigation, they conceded that it was the Travis County District Attorney's office that had truly hired Kamich, a notion that former DA Margaret Moore took the stand and soundly rejected, almost taking offense that she would hire someone with 5 years out of law school with no experience as a prosecutor to work in her office. And so we heard some information and some testimony about that. And, frankly, Austin Kinghorn saying, well, it's his office. It's Attorney General Ken Paxton's office. He could hire whomever he wanted to hire because it's his office. So him kind of saying that it was not that unusual. We go down to Article 6, which accuses General Paxton of disregarding his duty and violating the law when those whistleblowers were terminated, and that he engaged in a campaign to basically ruin their professional reputations. And this was particularly interesting testimony that we heard today from Henry De La Garza. Now, Henry De La Garza is the HR director for the Attorney General's office. He is also the person who advises staff in the office, all of the staff on all levels, about ethical issues. And he says that he was being presented with information that justified the termination of the 4 whistleblowers, from David Maxwell to Ryan Vassar. Interestingly, those 2 names, David Maxwell, who is the retired law enforcement officer, he was the director of law enforcement for the AG's office and was this sort of famed, if you will, Texas Ranger. He's actually in the Texas Rangers Hall of Fame. That they wanted their jobs back. They wanted to go back working, in the Attorney General's office. But he said that he was being told, and the information he was being given by Paxton's now, second in command, his right-hand man, that they were not working with him, that they were not carrying out, refusing to do investigations, that they were not being compliant, that they were being insubordinate. And so certainly from De La Garza's standpoint, there was reason, and he also pointed out that Texas, and certainly the Attorney General's office, is an at-will state. Employment is at will, meaning that an employer can fire you for no reason. No reason has to be given to you, and certainly that was the case. obviously this runs a little counter to the whistleblower law, and that's why we have a whistleblower law in effect in Texas. And I thought it was quite poignant of the defense attorney to point out, and he questioned, well, yes, you got this information suggesting that their terminations were legitimate and for legitimate reasons, but who was giving you that information? And it was coming from Brent Webster, who had been hired after, you know, all of this had been made public and after Jeff Mateer had already resigned from the office. And so there was question about his allegiance and just the validity and the authenticity of the complaints that he was taking to De La Garza about firing these 4 whistleblowers who were fired quite quickly after they filed that whistleblower report. If we turn to Article 6, Article 6 is the actual firing of the whistleblowers. Article 7 has to deal with the whistleblower investigation and the report that was created. And so after the whistleblowers were fired, the Attorney General's office itself launched an investigation, an internal investigation into the complaints filed by the whistleblowers. That complaint found no wrongdoing on the part of the Attorney General. And so the House managers argue that this was kind of a sham investigation that they called for, and that the report published false and misleading statements in Paxton's defense. Now, one of those false and misleading statements I've already talked to you about. It is the hiring of Brandon Kammick, and whether he worked for the AG's office or whether he worked for the Travis County Attorney General's office. The Travis County District Attorney's office. And we know that he did not work for the Travis County DA's office, as was stated in the report. But so that there was a misuse of really public resources to create this report that was just going to exonerate, if you will, Ken Paxton. Now, Paxton also hired an outside law firm to also do a report. That report, notably, also found no wrongdoing on Paxton's behalf. That report, though, we will note, came out after the impeachment of Attorney General Ken Paxton, after it had already happened, after the vote had happened in the House of Representatives. The next article that the witnesses that we heard from for the defense today talk about is Article 8. And that talks about the whistleblower settlement that Attorney General Ken Paxton entered into. And there was a lot of information about the lawsuit that the whistleblowers filed. Yesterday, we heard from one of those whistleblowers, Blake Brickman, who said that the Attorney General tied their lawsuit up in court. Their lawsuit was filed in 2021, I believe, and so it stayed in court for 2 years, tied up in court for 2 years before a settlement could be reached and anything could be made public, because one of the motions, if you will, that was filed by the Office of Attorney General froze anything from happening regarding the lawsuit. So it stopped discovery. It stopped the whistleblowers from being able to collect any information or get any information. And it was questioning whether or not the Attorney General of Texas and the Office of Attorney General could even be sued in a whistleblower complaint, kind of saying that the Attorney General's office was above being able to have that type of lawsuit brought against them. Now, we know that the Court of Appeals ruled in favor of the whistleblowers, saying that the Office of Attorney General and Ken Paxton therefore can be sued for the whistleblower law, that they are not above that law, but they are privy to that law. And so that certainly was some interesting testimony. And the House managers allege that all of that happened, and even entering into the settlement happened to conceal the truth from voters, because we know between when all of this is happening in 2020 and the lawsuit, the motion on the lawsuit in 2021, and when we finally reached a settlement, or when a settlement was announced, I say proposed settlement because the judge still has to approve a settlement, and it has not been approved by a judge, nor has it been paid out to the whistleblowers, that the election happened in that time. The 2022 election happened, and Ken Paxton was reelected for his third term. And the members of the House of Representatives believe that this settlement agreement was just done as a cover-up to conceal Paxton's wrongful acts and hide them from voters, and they argue that voters were unable to make an informed decision. This takes us then back to the articles that we did not hear about in the defense. The defense did not touch Article 9, which deals with whether or not Nate Paul hired Laura Olson, Ken Paxton's mistress, as sort of payment to Paxton for helping him with this case. We also did not hear the defense bring up a witness to speak specifically to Article 10. Article 10 is also constitutional bribery, but this article alleges that Nate Paul paid for renovations to the Paxton's home. And you also did not hear the defense bring up anyone to talk about that particular article. Now, Articles 11, 12, 13, and 14 are not, excuse me, I'm going to go back and recount this because, yes, those are the articles 11, 12, 13, 14 are articles that are not included in this particular impeachment trial. Those articles have to deal with Ken Paxton's securities fraud charges. He was indicted on a state level for crimes of securities fraud. Mainly the claim against him and what the indictment states is that Ken Paxton was working for a company. Tony Plohetski is joining me back now. He's back here, so you guys will be able to hear another voice. And not just
Have you been
my
talking
voice.
this whole time?
This entire time, I could use a sip of water. But basically that he was working for a company and was soliciting investors for that, but did not tell those investors he was working for that company, that tech company, while he was soliciting investors. And so that is what the securities fraud charges are. We're not hearing the articles of impeachment related to those charges and specifically
felony charges in state district court.
In state district court.
I'm going to give you a break.
Go. Look, my water is waiting. I'm waiting to take a sip.
So those felony charges, as we know, have drawn so much public attention because of the length of time that they have been pending. Those charges brought in Paxton Country in their home county of Collin County in 2015. There have frankly been a lot of reasons for delays, including motions on both sides of the equation. There have been other factors too, but one of the main factors with the state security fraud charges is the venue where the case was going to be held. Ultimately, it has been determined that the trial, if there is to be one, but that the case itself and a possible trial were moved to Harris County in Houston. Mm-hmm. Keep in mind that in recent years, the case was delayed because of Hurricane Harvey, which shut down the court system in Harris County. There was, of course, the COVID-19 pandemic, which caused disruption to court systems across the state and across the country. But as we have seen in recent months, if you have not been keeping up with this story, a new judge in Harris County, elections have also happened. So a new judge in Harris County, who is a Democrat, has essentially said that she wants to get this case back on track. So to that end, last month there was a hearing in Houston in her courtroom. Ken Paxton was there. I sat very close to him. He entered and left with a security detail through a non-public entrance. That raised some eyebrows. And the reason it did is because there is something of a belief that everyone in the criminal justice system should be treated the exact same way. Ken Paxton, in this instance, was not treated the exact same way as any other defendant is. Make of that what you want. We also heard an expression of concern about security, so that also might have been the reason for his entrance through a non-public entrance. I just wanted to tell you the whole story there. But nevertheless, the judge had the attorneys come to the bench. Dan Goudeau, who is part of Paxton's defense team in this impeachment proceeding, represented him there. The prosecutor, the special appointed prosecutor, is a man from Houston, an attorney from Houston named Brian Weiss. He stood at the bench, and the judge basically told them, this case, we need to move this case. There was obviously a discussion about how this impeachment could play a role in the scheduling of that case, but the judge concluded by saying, I would like for this case to possibly go to trial as early as February 2024, and let's go for a resolution. After that, it was mentioned by Dan Goudeau that Ken Paxton, should he be convicted in this impeachment trial, may have an interest in settling the case. He did not say plea. He did not say, what kind of resolution, but he did toss out that possibility. And Ashley, here's why. If Ken Paxton is convicted in this impeachment trial
and removed from
office, he still does have his law license.
Yes.
If he is convicted of a felony, he will likely lose his law license. And so out of the protection of his law license, Goudeau suggested that Paxton may be willing to resolve the state felony charges.
Nonetheless, those 4 impeachment articles will not be heard at this time. The court decided, and interesting, the Senate could have heard them one at a time. And we could have taken this, we could have had many trials, and we could have gone one by one, but they decided to remove those 4, given the nature of what's happening, behind the scenes with those with that indictment and those criminal charges, and move forward with where we are. And so that's those 4. But then at the end, we get to the catch-all articles, and these are the articles that are remaining, that the court is hearing, that sort of, and we call them catch-all articles because they allege basically that Ken Paxton Article 16 is conspiracy or attempted conspiracy. I should say and, not or. If you're illegal, you know there's a difference between and or. That while holding office as Attorney General, Warren Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more of the articles. So not even that he committed the acts, but that he conspired to commit acts that are alleged in the articles. And that is why that certainly is a catch-all.
Yeah, and then if we look just to Article 17, misappropriation of public resources, essentially that says Paxton misused his official powers by causing employees to perform services for his benefit and the benefit of others. And then really the last 3, there is the Article 18, that's your dereliction of duty article. Just says kind of broadly that Paxton violated the Texas Constitution, his oaths of office, plus statutes and public policy against public officials acting against the public interest. And then 2 more, Bob, if you're still with us, Article 19 and Article 20. Article 19 is unfitness for office. It alleges that Ken Paxton engaged in misconduct such as character as to indicate his unfitness for office as shown by acts described in one or more articles.
The last one, Article 20, abuse of public trust. And it alleges that while holding his office, Paxton misused, or failed to use, and that or could mean one or more, any of those, his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice.
Announce that you're going to have closing arguments in the morning
Oh,
before I adjourn for the day.
we are listening.
And adjourning for the day, he says.
So he says they're going to do closing arguments in the morning.
Mr. President.
Let's listen.
Do you close? tomorrow?
Yes, Mr. President, the House will have closing argument.
On the record?
Yes, Your Honor. The Attorney General will close tomorrow. Closing argument.
Okay, for the record? (9 a.m. as always. 9 a.m. We are adjourned for today.
Well, there it
Members,
is.
before you scatter, talk to your two leaders here.
They're clearly going to go back to caucus in the back, and so this is generally you see the two leaders being Senator Whitmire and Senator Brian Birdwell, who are over what happened. Now, one of the things that I think is interesting that they talked about, and I don't know if this is going to happen, they were each. The rules stated they were going to have an hour each for rebuttal evidence, and it would seem as though with them announcing that they're going to close tomorrow, it is a bit unclear to me if they're going to close after giving that rebuttal evidence or if they're just going to...
Or skip
it all together and just get right to the closing. And so we certainly want to thank you all for sticking with us. You can see the senators packing up their things. They're going to go caucus. That means they're going to go meet and talk, and then they will come back tomorrow morning at 9 a.m. for closing arguments in the impeachment trial of suspended Texas Attorney General Ken Paxton.
And we will be sitting right here ready to go before 9 o'clock.
We actually will be bringing you those closing arguments on television, on KVUE. So be ready to watch KVUE. Of course, if you prefer KVUE Plus, if that's how you're watching us now, or you prefer YouTube, you'll also be able to see it there. But just if you like to be a little old-fashioned and turned on your TV,
we'll be there
to the good stations. Use that. We'll be there too on KVUE. So just a couple of options you have to watch.
Have a great night, everybody, and we'll see you bright and early. Not too bright and early, but the reasonable time of 9 a.m. in the morning. Have a great night, everybody.
Bye-bye.